Leave to mention one matter, my lord. This matter was mentioned twice before your lordship on 10th and thereafter again on 24th. My lord, the interim order is expiring today, but I have been told, my lord, the file is not traceable. My lord, we mentioned on even on 24th, the lordship was pleased to allow the mentioning. Mr. Banerjee, my junior, my lord, he mentioned the matter. My lord, the file is not, even in the mandamus section, my lord, I am told, my lord, the file is not traceable.
Then, Mr. Sakiki, what can be done? Where is the file? What is it lying?
Lastly, it was appearing in the monthly list.
Lastly, it was appearing in the monthly list before your lordship, in your lordship's court, my lord.
September monthly list.
In September monthly list is was appearing. And the interim order is expiring today. We mentioned twice, my lord.
My lord,
Let me see.
my lord, same fact, my lord.
Uh.
My lord, same fact, my lord. I mentioned motion.
So it's a extension of interim order. It will expire on 30th of November.
File গুলো আনিয়ে নিন।
Extension. লিখে দিয়েছি ওই তারিখ অবধি।
এক্ষুনি পাঠিয়ে দিন।
File is not
ওই extension উপরে লিখে দিয়েছি।
Restoration application, my
Please,
respect of years. Another is review application.
see if the file comes, then a supplementary list might be published.
দেওয়া আছে, স্লিপটাও দিয়ে দিলাম।
Another is review application.
নোটিশটা দেওয়া ছিল না?
Review, please hand over the slip. File গুলো আনিয়ে যেগুলো আজকে, Mr. Siddiqui, have you mentioned that when it is expiring? Please mention. In the slip, please mention.
My lords,
যেগুলো আজকে মেনশন আছে সেগুলো একটু
it is expiring on Sunday, my lord. That is on 30th November.
Yes.
My lord, may I have lost mention, my lord, one matter where my client has been, my lord, fined 1 lakh rupees for, my lord, there is a BJP dharna before there is a BJP dharna before the Navanno, and for that 10 hours, my lord, has been detained my car. And my lord, after that, my lord, my car has been started, but police, without assigning any reasons, due to
No. How is it group 1?
No, group 1 is a land. Allegation is, but I'm carrying the mines and minerals. No allegation. For that 1 lakh rupee has been given. Fine.
Yes.
My lord, under compliance circumstances, I mentioned, my lord, petitioners are the leasehold holder of the land. My lord, the eviction notice has been served, my lord, due to pendency of the appeal before the magistrate. The eviction notice has been served. The date is 9th December, my lord. Kindly
Motion,
my lord.
when have you filed?
It is running in the monthlies of September, my lord.
দেখে নিন ওটা।
This matter is pending since 2018, my lord. This is a matter.
Motion.
Motion, no, there's no motion actually.
Hearing Mr. Chakraborty, please wait. Let me see.
No, there is the direction for filing affidavit, but no affidavit has been filed.
Then I will consider when it will be. Not now. Please wait.
My lord, may be permitted to mention a review application in connection with a civil revision, lordship. The next date is on 1st, my lord. It will become infructuous, my lord.
Yes.
My lord. Deeply obliged, my lord.
Call the list.
Lordship, I am appearing on behalf of the petitioner. Lordship, in this matter, there are 2 corrections. In the earlier occasion, 1 correction was done, but Lordship, the next page, that correction was not done, Lordship. Page number 2, original judgment order dated. Page number 2, Lordship.
Yes, page number 2.
Page number 2, Lordship, last line. Husband petitioner is not in a default in paying of maintenance to the son, Lordship, not alimony.
No.
Which is pending before the.
What is pending? Provided that the petitioner husband is not in default in payment of alimony.
Yes,
Let's
Lordship.
see.
Now, the second page, it is indicated, Lordship, that's
Alimony.
alimony.
Yes, that I have directed that if there is no is not default, then only expeditious hearing. If he is in default, cannot be. That was the order.
Instead of alimony, it should be maintenance, Lordship.
Same thing.
Lordship, kindly rectify. Otherwise, maintenance to his son.
No order was passed in for maintenance to the wife.
No, there are no.
I have not indicated alimony jaga.
Instead of alimony, kindly.
It has been pointed out that in the
I don't know for I'm for the petitioner, my lord.
treat it here.
Interim order is expiring today.
You are for the
I'm for the state.
Which-
I'm for the respondent union of India.
But the only thing is, my lord,
what is the dispute?
dispute, my lord. Dispute is, my lord, the petitioner's land was purchased in 1976 from erstwhile Burns and Company. Now, railway is claiming their land, and state is saying their land under the estate act. There's a fight between state and union.
So what do you want here?
I have got a status quo order. I have purchased it from Burns and Company.
No. What is the relief claimed in the writ petition?
That their name be mutated in the record of rights since they are holding the title deeds. Lordship. We are disputing the
Vesting order, how can it be set aside in a writ petition?
But it's not vested.
That's your prayer. Prayer B. To recall the orders claiming that the property stood vested in the respondent number 1. That's your prayer. Prayer B.
But respondent number 1 doesn't have any right.
You have paid for setting aside the order of vesting. How that can be done in a writ petition?
But,
And you want a declaration that it never stood vested. How that can be decided in a writ petition?
no, my
Whether it stood vested
prayer.
or not
No,
vested.
my lord. I do not want a declaration that
These are the declarations you have sought for.
I understand, my lord.
If you say that you do not want, then nothing remains in the writ
No, but
petition.
what I praying for is that my land is cannot be with the union.
You have challenged the order of vesting.
There is no vesting, actually, as such. There is no vesting.
What is the order which you are challenging? Please show me.
There is no order, my lord, actually, as such. What has happened, my lord? We had gone for mutation of the land,
Yes.
but mutation was refused.
Yes.
Mutation was refused on the ground that this land belongs to the central government.
Yes.
It all belongs to the central government.
To mutate the
Tribunal.
inaction
No,
part of an authority under the Land Reforms Act. If there is an inaction, you have to approach the tribunal.
No, but here,
petition is maintainable.
no, it is not so, my lord.
You have said, sir, that
I
I
understand.
applied, it was not being mutated. That's the
Kindly
inaction.
consider the prayer.
That's your submission.
No, kindly look into the fact. The fact remains now.
I
LRTD does not have,
I only want what is the relief you are
but
claiming.
LRTD does not have jurisdiction. The Land Reforms Tribunal doesn't have jurisdiction.
Show me what is your prayer, what relief you are claiming.
Yes.
But relief A is what I am claiming, my lord.
Yes.
If A is granted, everything is granted.
Never stood vested.
Yes.
You are seeking a declaration. How that can be done in a writ petition?
But LRTD does not have jurisdiction over this property, my lord.
Whose inaction you are claiming?
Union of India, railways.
The vesting.
There is no vesting.
Then you have to file a suit.
Railways have
Then
claimed.
you have to file a suit for declaration.
No, my railways have no, my lord.
Then you have to file a suit for declaration. If you seek your title, you say there is no vesting, you have to file a suit.
But here, my lord, what has
If you are
happened? my
not
lord?
ready, I can take it up tomorrow. But
Yes.
on this, I'm not inclined to extend. Because prayers are not maintainable. As it stands, the writ petition is not maintainable.
And the state and union both are taking the same point that this writ petition is not maintainable in view of this fact.
Was it gone into at the time of passing of the interim order?
Well, that point was taken.
That
That
point was
point
taken?
was taken.
And status
Was it
quo was
decided?
no.
The time of extension, I'm raising this point. Please satisfy, otherwise no extension.
আমাদের opposition এর কতটা কথা বলবো?
I may come back then.
Yes. When?
Well, give me the date. Third.
Which date?
Only my lord, Monday and Tuesday, my lord.
Monday, Tuesday. I am also not. I am not.
I'm just taking excuse, my lord, Monday and Tuesday.
Third or fourth, my lord, I can come back.
Absolutely. Yes, they know how to adjust. Yes,
Third.
next.
Madam, I'm appealing for the petition. I'm appealing for the petition of the whole the municipality.
Yes.
Extension of interim order, my lord. Extension of interim order, my lord.
Yes, what is the scope of the writ petition?
My lord, we are constructed and we are constructed one toilet come restroom for the vendors. Earlier, a toilet we are renovation, and thereafter we are construct one restroom for the vendors. And by the land was belongs to the development department, government of West Bengal. On the basis of that, and by the consent of the PWD department, but we are constructed that, and now the order is passed by the SDO to demolish the entire building. This is my subject.
And the appellate authority affirmed the said decision.
Not only that, my lord.
Division bench already directed.
Thereafter, my lord, we are renovation and construct by the consent of the
Where is the writ
PWD.
petition? I could not find out the writ petition till
My
now.
lord,
Affidavit in opposition, affidavit in reply.
Everything.
Where is the writ petition?
clear, my lord.
Yes.
Kindly go on to page 41.
My lord, we are construct for the purpose of the public purpose, my lord. We are the renovation of the toilet and vendors.
Kindly turn to page 41. The order passed by the Honorable Division bench.
That land was belongs to the my lord, development department, government of West Bengal. For that reason, by the consent of the PWD, we are constructing the building.
So what is the order under challenge here?
My lord,
10-4 was issued.
the
District Magistrate directed for removal under exercising power under section 10-4 of the Bengal Highways Act. Challenging that order, my learned friend is before your lordship. Previously, my lord, can I turn to page 41? Earlier litigation, my lord. I am drawing a lordship attention page 42, last but one paragraph.
Yes.
the lordship can you see?
The counsel for the appellant has submitted that as per the decision taken by the district magistrate,
Who
my
was
lord,
the appellant? You.
there, my lord, no.
Here, who was the appellant?
But I'm going to.
Here.
The
Municipality.
Municipality.
Municipality was there.
Municipality.
no, I'm the
Private-
complainant.
All right.
The counsel for the appellant has submitted that as per decision taken by the district magistrate, the municipality has started works under the Green City Mission and had constructed double-storied RCC building consisting of public toilet as well as stalls in subject land. Admittedly, the land belongs to the Public Works Department, PWD. The said construction was made by the appellant without getting approval from the PWD. The writ petitioner made complaint against the municipal authority that constructed public toilet and stalls due to
Who was the
sewage.
writ petitioner?
But
I am the writ petitioner. There.
They are there.
In that writ petition. Yes.
And considering the said allegation, my lord, the report was sought for by from the special officer. And now, my lord, can you turn to page 44?
Yes.
In compliance of the order, my lord, from the middle portion, my lord, will find Honorable Single Judge, Assistant Engineer, Huldia Highway Division has issued notice to the appellant such and such, directing the municipal authority to remove the structures obstruction to the satisfaction of the highway officer. The counsel for the appellant for the submits the assistant engineer without giving a so cause notice and an opportunity hearing passed an order for removal of obstruction. The counsel for the respondent has submitted the appellant had made construction without the approval of PWD. Admittedly, the land belongs to the PWD. Allegations by writ petition has been confirmed by the report of the special officer. It is crystal clear from the report that the appellant has made illegal construction over the PWD, due to which ingress and egress of the writ petition has been stopped.
17 feet is, I mean, this wide road.
Please allow him to make his submission. You will be getting your chance. Yes.
Now, my lord, kindly consider the operating portion, page 46.
Yes.
This court has not found any illegality with the order passed by the Honorable Single Judge, and there is no merit in the appeal of the appellant. Because the Honorable Single Judge,
The order passed by
Yes.
the single judge.
Honorable directed for removal of the, that your lordship will find, page 40. Penultimate paragraph is since, my lord, will find, starts,
So directed to initiate a.
no, proceedings for removal of the impure.
Yes. So proceedings was directed to be initiated. The division bench said yes. Now the proceedings has been
Yes,
initiated.
now, my lord, can turn to page 47.
Page.
47.
Yes. What is
The order
this?
passed under section 10(3).
10(3).
Yes, my lord. My last paragraph, my lord, will find.
Yes.
Now, my lord, as no steps has been taken, the writ petition, who is the private respondent herein, came before this honorable court. Page 48.
Yes.
My lord, can you turn to page 50? Is the relevant portion, my lord, I am reading out for your lordship. The only issue under consideration, my lord, got it, page 50 from the top. Consider ought to be illegal encroachment of the government land or a highway. My lord, this was the issue. In view of the above, this court inclined to hold that the direction of an inquiry and report filed by the block land and land reforms officer Sushanta as to whether there is a substantial space of plot number in front of the rising plot number such and such for egress and ingress of the private respondents is dehodes the provision of section 10 of Act of 1964 and is required to be set aside quashed. No such inquiry is called for under section 10(4) of the Act. Any such inquiry, if already made, shall not take into consideration. The appellate authority is dealing with the appeal under section 10(4) of the Act. The appellate authority shall deal with the prayers of the private respondents alleged encroachers in terms of section 10(4) of the Act and pass a reasoned order speaking order affording reasonable opportunity of hearing of both the parties.
Yes.
Now, my lord, can you consider page 52?
Yes.
That your lordship will find. Page 53 is the relevant portion. Order number 4, last paragraph, my lord.
Plot number 751 by 1452.
Yes. Now can you turn to page 56?
Here it refers to petitioner. Who is the petitioner?
Eh.
Here in this order,
Petitioner is the private respondent hearing.
you
Yes, because there is in section.
also encroached.
No. Subject to
Yes. Petitioner also encroaches 110 square feet.
Yes.
yes, if that be so, that should be demolished. If that be found.
So you have also encroached.
Yeah. What plot number? 751 by 142.
1452.
1452. 1452, yes. Bata.
So there is one Sulab toilet and
Stalls.
Provision the Sulab toilet.
and also you have also encroached.
Yes.
Yes. Then
Now, my lord,
is under challenge.
now this order is before your lordship under challenge.
SDU, my lord, pass an order.
No. DM.
So this is the DM.
DM order. Now, my lord, page
Appellate
58.
This.
Yes.
What is the ground of challenge?
The ground is that land belongs to development government of West Bengal. Pursuant to the consent by the PWD, we are constructed. I have the papers, my lord.
Under what provision of law?
My lord, we are
Encroachment upon the highway?
Papers. No, my lord. By the consent of the PWD, we are renovation the toilet and rest.
Under what provision of law this consent was given by the
They are giving
Who
consent.
is appearing for the PWD?
My lord,
Mahato, you are representing.
yes, my lord, my stand is my lord, the order of the appellate authority is justified and it should be my lord.
Why did you give this consent?
My lord.
The consent is here.
Section
Give consent.
My lord, Bengal Highways Act, section 8,
Not only
permanent
my lord,
permission cannot be granted.
my lord, by the
Show me the permission
And in terms of section 8,
granted for temporary purpose.
temporary purpose.
And it is entirely used for the public, my lord.
Maybe.
My lord, not only there, my lord.
For that you will be encroaching the highway.
No. That is, my lord, we are not encroached.
Since you are an authority.
My lord, that land was
Since you are an authority.
Yes, my lord, that
So
land.
you have the right to encroach
No,
upon
no,
a public
nothing.
property.
But the land was belongs to the development government. So you must kindly see the annexure, my annexure, page 54. Annexure J, page 54. The land was belongs to development government of West Bengal.
Yes.
That is not entire land was belongs to the government. And by the consent of on 89, PWD permitted me to renovation the toilet and bathroom and also for the public and also the store. For that reason, we have renovation for the public. And it is Mr. My lord, we have collected the paper last 2 weeks back, my lord. On that time,
The proposal for transfer.
Yes.
That is the final order of
Yes.
transfer. Show me.
there is PWD.
Show me. This is only a proposal.
Then my lord, also we can adjourn for 1 month. I shall collect one. Actually,
Adjourn for
for 2 weeks or 4 weeks.
Well,
I shall collect.
proposal is way back in the year 89.
And this thing was
After division bench, my lord, division bench is categorically held. After that, whether the
my lord,
bench can
before the
reopen that issue.
authority, before the authority, this document was
Sir,
not
it is
placed.
nothing but a reopening.
My lord,
You have not taken the stand before the authority.
Before the authority.
My lord, the division bench, after the division bench,
Allow him to submit. He was a private respondent. You objected to the interim order. I've heard you. Let him make his submissions. You cannot stop him.
Not only that, 17 feet wide road is there in front of my permission, household permission. Not only that, my lord, by the pursuant to the direction consent by the PWD, we are renovation of the toilet. The toilet was established before partition, my lord, before independence. Thereafter,
Where is the permission given by the PWD? PWD has not given any permission.
I shall produce you before lordship.
Nothing was produced before the authority. Cannot produce new documents here.
When I have collected and produced before your lordship. The permission of the PWD, I shall produce next course of next day, my lord. I shall collect.
Tuesday.
Well, only 1 week. 1 week of
Tuesday.
No, I shall collect the paper from Huldia. We'll go to Huldia and collect the paper.
What is email? Email ask the authorities to produce that. That will be because you know that there is a permission. So the documents must be with the authorities.
I shall collect.
Ask them to yes, ask them to furnish.
Fixed on 4th.
4th. All right. The interim order is still
Today, 30th.
30th. So, Mr. I have to extend it
Yes.
to limited period.
স্যার আপনি যদি দয়া করে একটু ছাটেন তাহলে আমি ঢুকি এক্সটেনশন অফ এন্ট্রি হবে না
Or only extension of interim orders. Senior advocates do not come.
I have no animosity with the honorable judge. Don't have any animosity with the honorable judges. If I
Senior advocates
in an attempt to earn something, the court will prevent me.
Have to justify their presence.
Justify my presence, saying what is the matter about. Can you see the lord's order already there in your lordship?
Show me what is the writ petition about.
Well, the deed petitioner is I am a lessee. There are covenants.
What is the prayer in the writ petition? Please show me that. Page 26.
Smile.
Hmm? is expired.
Yes.
Yes.
Where is the provision for extension?
There is a
That is your
judgment,
prayer.
there is a judgment of my lord, of your lordship to the coordinated bench.
So yesterday matter was dealing by the Honorable Division Bench. Mr. Dey was there. I was representing the corporation. The Honorable Division Bench held that the remedy of the petitioner, so far as where the lease has been expired, remedy to claim damage before the appropriate court. Plus, if the order has not been uploaded, yesterday the judgment was delivered in open court. Mr. Dey was representing state and I was representing the corporation on the identical issue where the prayer for
Also my prima facie view. That is
Prima
why,
facie, yes.
yes, prima facie. I've said prima facie.
This was the
But
same
now,
part here.
now Mr. Basu, the division bench has
No, I
passed
don't,
an order.
I don't have the order. This is, my lord, subsequent. The enactment which has come into, this is subsequent one.
Mr. Basu, only one thing. If there is a contract, it stood expired. Maybe for certain reasons you could not perform some duty, or maybe due to the inaction on the part of the other side. Now, what
That's the
is the remedy under the law? Extension.
Extension is granted, my lord. Can you see this order?
The coordinated bench, Mr. Basu.
It's a
I
lot-
can-
I know your lordship may refer this.
Yes.
Kindly come to paragraph 21, paragraph 18.
so that order has not been uploaded.
Division bench order.
Tuesday.
Tuesday, Monday.
Order has been passed, Mr. Basu.
Already division bench
Please
has
give a
passed.
copy to Mr. Basu so that.
So I can supply the order has not been uploaded. I can supply the case number.
Keep the number so that once it is uploaded, he can also get that number.
Can you see this order once?
Yes.
Can you come to paragraph 18?
Yes.
1304.
Materials
2025.
with this court, the revocation of suspension took place on the part of the respondent such and such. No explanation has been given on the part of the respondent authorities why they prevented them from revoke the order of suspension. Their suspension was there. By the non-revocation of the suspension order, I could not, this petitioner could
The
not.
remedies provided under the law.
My lord,
What are the remedies provided under the law?
damages, but no, why I am submitting, my lord? If it is at the instance of the lessing Article 12 authority, it is not a private party. It is not a private party. That is the distinction.
Mr. Basu, there are a line of decisions which says merely because one of the contracting parties, a state or its instrumentality,
And the other judgments are there.
In
The
the-
government authority should not take this point.
this is purely a commercial
Commercial.
dispute. So for that, whether a writ petition will be maintainable, Mr. Basu.
So that point they cannot urge. They cannot urge because this point was urged. Can you see your lordship's order? The order sheet. Justice Sengupta has already
Sen.
decided that point
What?
in this matter.
Show me that what
this matter.
judgments was taken into consideration.
In this matter, so it is res judicata among the parties. It's a res judicata.
No, Mr. Basu, no.
So can I am relying on 60 Supreme Court.
Yes. Show me what decisions were considered in this.
Kindly see
I'm
your
a party
lordship.
to a decision that says no.
Kindly
Type of
yes,
petition is
kindly
not
come
maintained.
to page.
Show me which one of the authorities were considered while arriving at a finding that this writ petition is maintainable.
Considered or not considered, they cannot take this point.
I am taking
That is-
this
that is
point. They are not taking this point. I am taking this point because at the time of extension, it is to be considered.
Yes,
whether-
yes. There I am not hearing the issue. Now kindly come to supplementary affidavit, page 7, or your lordship can get it in your lordship's
Lease.
the
Judgment.
no the order sheet.
Orders.
Kindly see. Order dated
Second May 20.
23.
Second May 2023.
Yes.
Yes. When the interim order was granted.
Did see this interim order is continuing.
Yes.
What is the nature of the interim order?
Not
That
to assign the
Allot to somebody else. Not to allot to somebody.
If you lose Mr. Basu, you will compensate. That terms can be imposed while extending.
Court can impose anything.
Yes, yes, yes.
No
So-
doubt about that.
So security, are you interested in putting the security as a condition for?
So now the situation is, I sustain loss at the inaction on the part of an Article 2 authority.
Mr.
Can you see, balance this? I sustain loss at the instance of the Article 12 authority, and court, having me prima facie satisfied, grant an interim order, and I say under 66 Supreme Court, it is res judicata among the parties.
Order dated, order dated.
Again, May 2023.
Yes, second May I've got. Yes, now I've got. Yes.
In the interval, 5 years from, just a minute.
2022.
Subsisting as on 2nd of May 2023.
No.
When it was
This
subsisting.
is a previous round of litigation was.
It was
It was, my lord, 6th March 2017.
so it expired on 5th March 2022.
And prior to that, my lord, I made the representation and earlier proceedings was filed. That is not maintainable when there is required of filing of evidence. If there is something admitted, what is admitted here? Lease was granted. They could not provide me the road. I applied to them. Some other allottees encroached my property. They took steps, given cognizance, lodged FIR. Nothing could be done.
The disputed questions of fact.
No. Had it been any disputed question of fact, I will not move.
These are the disputed.
If any disputed question of facts my lord find, I will not move my case. In a case where facts are admitted, whether that should be relegated after so many days, the alternative forum. That is also the judgment your lordship knows. Whether I should be relegated on that date after the exchange of affidavits, if there is no disputed question of fact. Had it been, my lord, require evidence, I cannot stand in the way of dismissal of the writ petition. I cannot. But kindly once consider, is there any disputed question of
What
fact?
is the violation of the statute which you are trying to canvass?
My lord knows section 108 of the TP Act is a lesser duty. It is a lesser duty to provide to get the usufruct of the lease to the lessee. What is that performance?
But here, what violation of the provision you are?
You are unable to give me the usufructs of the lease. I have paid the entire money. It is your duty, is a lesser. Kindly recall your lordship's civil acumen here. 108 clearly says.
In a different jurisdiction now, Mr.
Nothing is, my lord, beyond civil, except in criminal proceedings.
Yes.
So, my lord, it's a duty. I repeat, my lord. If your lordship take Mulla's TP Act, my lord will find a passage on that. That you, the lesser, you cannot say, give the lease, get the money, and thereafter you will perform your duty. To allow the lessee to get the benefit of the lease. I repeat, well, I will not say anything which is not admitted.
All right. Order was passed yesterday.
Yesterday.
The interim order is still
Today.
till today. No, extending it till 4th, and keeping it on 3rd. Where is the division bench judgment, Mr.
Let me
Basu?
see. But I don't know. If I find on the pattern the point division,
Yes.
there's something.
At least
In
there
this
were-
particular case, there was an order of suspension.
View. That was also my prima facie view.
No, that privacy view, if without any division bench judgment, I will try to convince your lordship. But if the division bench judgment is over there,
No, fortified by division.
that I'm saying. This has to be looked into under which context the judgment was
Yes,
given at.
that has to be. That is
Whether, my lord, this identical fact, whether the ratio is there, or on the facts is decided, or any judgment, my lord, has not been considered. These have to be looked into.
division bench, Mr. Basu.
No
whether it-
comment, my lord. No comment, my lord.
Coordinate bench.
No comment, my lord.
So that's binding. If it's a division bench, coordinate bench,
My lord,
you can say
my lord,
Lordship can defer.
my lord has come across so many judgments where division bench passed a judgment without looking into the, my lord's Supreme Court judgment.
that, Mr. Basu, it's difficult now yet.
What?
Uh,
It is unknown to my lord.
Asun.
Lease was, my lord, cancelled. The writ petition filed, your lordship was ultimately hold. So no, it was wrongly cancelled, wrongly terminated. In your lordship's view.
Mr. Basu, there is a distinction. If it's a statutory lease and there is any violation of any statutory provision, yes, you are right, writ petition. But if the nature of the contract is purely a commercial
So
contract,
that I will satisfy. your lordship.
merely
Even if-
because
even
one of
if
the
it's already commercial contract.
That is the exactly point held by the Honorable Division Bench.
merely
The
because
commercial contract.
contracting parties is a state that
That
does
will
not
do.
make a
Thing for Marfatia, kindly recall Marfatia.
Mr. Basu, all those judgments were
5 pages.
referred to, considered. I am a party to a division bench judgment.
Marfatia
is
is 5
why-
pages bench.
That is why I am telling you, I am a party to a division bench judgment on this. Many of the Supreme Court judgments were also,
But in a given case, my lord,
also
entertained.
considered. You can also find out that judgment. I do not recollect the name. I am a party to a division bench judgment.
There are contradictory judgments.
I authored that judgment.
That
Considering
may be lordship mind. But problem is, my lord, only because it is a commercial contract by a statutory authority, which requires no evidence to be adduced, whether it is maintained.
That is a distinction.
Distinction, I want to,
That is a
I want to
distinction.
enter into that distinction.
Yes, that is a distinction. That has to be seen whether that
Facts of the
distinction.
case.
Yes, that
It is the facts
distinction
of
is
the
there.
That's why at the outset I said, if my lords find there is any evidence to be looked into, I will last person to move it. Because I know.
See another division bench as he says on these
Let us
facts.
see. Let us see.
On these facts, it has been held.
Now, I am giving an instance. The petition pending, termination is bad. Your lordship held termination is bad. Will your lordship will then relegate this party on the basis of your lordship's judgment that termination to go to file a suit?
Depends. What is the scope?
That I am saying. So the subsequent enactment says no extension. It cannot, my lord, be imposed on a league which was pre-statute.
One thing then, Mr. Basu, is after it has got terminated
Not terminated, expired.
Expired.
by efflux of time.
Efflux of time.
Efflux of
Could
time
soon
and
expire
thereafter.
by efflux of time. Then the question comes, when you are praying for this extension at a point of time when the new policy has come.
No policy
Whether-
enactment. I have asked for
Yes,
before
statute, when
that.
the new statute has
Before
come.
that. Before my, it is continuation. Admitted fact that I cannot provide you this. All are admitted.
All right, let me
Let
see.
us come back.
If any of you get that judgment, please supply.
Yes,
it
Lordship,
to me,
I will get it.
Because
If
I
Mr.
will
Basu
get
is a
it.
busy man, he will not get time to look.
আজ নেই কোনো খোঁজা মাছ অবস্থা
Find out from the server, I have said.
এ আমাকে এসব বলে লাভ নেই they will supply me.
That is why I have told you. You do not have time to.
No, I don't have knowledge of getting from server.
We are appealing for the response. We have already filed our opposition. And reply also, when we had the
Extension.
Lord, we had the primordial objection about the maintainability, which this point has been taken in our opposition also. The order.
What maintainability?
The order has been passed. Lord, the order. Lord, your lordship. The order has been, the order under challenge has been passed by the ADMLR. This is an applicable order under section 15 of the West Bengal Manual.
Rule 51.
Rule 51 of the concession rules.
Yes, my lord.
So let it go, let it go for an appeal, let it be disposed of.
The renewal application has been made.
Nothing depends, the order has been passed by the authorities.
Company did not take when this interim order was passed.
That was
Take this
left
point, and alternative remedy is not an absolute embargo.
Then my lord.
Alternative relief is not an yes, and you have not taken that point. This interim order was passed at that point of time. It was available to you.
Perhaps, Lord, if I am not wrong.
It not be said that you have waived that.
When the matter was more judicially appeared, Lord, I raised this point.
You have raised this point, considered even then, interim order passed, then your objection has been overruled. You have accepted that.
No, I did not.
And no hearing the four corners of the memo.
You accepted that, meaning that order stood, then time to time it was extended, meaning thereby you have accepted that order.
Has been also given on an application.
No,
Yes.
Well, nowhere in the four corners of the memo, whereunder it is crystal clear that the state authority did not renew the mining lease due to pendency of an appeal, MAT 2037/2014, and the coordinate bench has already dealt with the matter.
All right, the interim order is still today.
Still to this.
Affidavits have been filed.
Yes, my lord.
The interim order.
Has already been disposed of.
This can is for extension.
But CAN 2 has already been disposed of by earlier order dated.
Earlier order.
Can 2 was disposed of.
Already
Yes.
Nine. যদি can 2 টা
Honorable Justice Parthasarathy Chatterjee dealt with issues.
Sen,
And
Prasad
before
Sen
the-
or Chatterjee?
Chatterjee.
No. Today, have you filed any application or?
Not today.
All right. আগেরটা দেখে নেবেন।
The matter is extended till
February, end of February. Yes.
He will be in the meeting order.
Yes.
I'm appearing for the petition.
I'm
Opposing this.
This was my writ petition, wherein an arbitral award was being enforced the land revenue after a span of 10 years. I had raised the point of maintainability of the proceedings as well as the manner in which the recovery procedure was taken up. There was an order of 29 July where prima facie finding in the court directed me to furnish the security. I have deposited the security. There was an interim order. Interim order was directing them to file opposition, and the interim order was expiring on 30th of this month. Since no opposition was filed, I was
Lord,
always
not filed any opposition.
My lord, because due to death of this advocate on record, my lord, Mr. Kaustubh Chandra Das,
How soon can you file?
my lord, within 2 weeks. But before that, my lord, may I submit before your lords? This matter, my lord, certificate was issued, MSME award was issued by the Madhya Pradesh. Thereafter, my lord, they preferred an appeal. They preferred a writ application before the Madhya Pradesh High Court. Madhya Pradesh High Court dismissed that writ application. They preferred an appeal. That was also rejected. Thereafter, the SLP was filed before the Supreme Court. My lord, that was also dismissed. My lord, again the certificate. My lord, may I? Thereafter, one arbitration application filed before the City Civil Court. They have withdrawn that said application.
Lordship, what my
Admit.
learned friend is saying, I don't want to get into all this facts.
No. There is, my lord, second question, my lord, the maintainability of this writ petition. My lord, the Revenue Recovery Act, 19, Revenue Recovery Act, my lord, section 4(2), my lord, specifically dealt with the civil courts, only the remedy lies against the award, against the certificate proceedings. My lord, civil court is the jurisdiction. They file the writ petition and totally abuses process of the court.
Why did you not raise this point?
Initially, I raised this point. My lord, kindly see this order.
When?
My lord, first order. There is only one order.
No, by which order this interim order was passed?
29 July, because there was a first round of
29th of July.
Yes, there was a first round of litigation by this
Number
honorable court.
of litigations filed before this court.
In accordance with law, we had raised a point of jurisdiction not considered. Then the learned court,
My lord-
honorable court directed to furnish security. We furnished security. There was a direction for filing affidavits. Let them put in his affidavit. We'll argue this point.
Security has been put in.
Security not only, but out of two
File
courts.
your affidavits, it will be hard.
Interesting points.
Who is for the state?
Amitabh Roy, the learned GP, was appearing.
Then GP, now who is appearing? Devduti Dotto. Mahata, can you appear?
My lord directs, I can appear.
Yes.
If my lord directs, then I can appear. But
The GP was appearing at the relevant point of time.
Or we serve a notice to the learned GP, whatever your lordship is.
You can appear, no problem.
My lord, there are 2 crores of rupees, my lord, lying in the only 59 crores, 59 lakhs they have deposited before this court.
Award of
কি বললাম
কপিটা দিয়ে যাবেন।
Item number 9, sir.
Lordship, for the petition, Your Lordship, I'm led by Mr. Shampanshu Dasan. Your Lordship, interim order is expiring at the end of this month. If it could be taken up on any day coming week, Your Lordship, this is regarding, they have determined my lease. I have on the which I have challenged. And the stay was granted by the order dated September 26, 2023.
Yes.
Okay, I'm appearing for the ADDA. My lord, in this matter, my lord,
The lease for.
Lease was for construction, Your Lordship. We failed to construct. There was a round of litigation. The court ordered to reconsider.
Where is the contract?
The contract is at page 137, Your Lordship. Subsequently, on the basis, Your Lordship, the court directed to reconsider. They reconsidered and condoned and told me to submit a comprehensive plan. I submitted the comprehensive plan. Subsequent to that, they did not do anything. I gave multiple representations to whether I should start the construction or not. Thereafter, they again conducted a hearing and again determined the lease on the same reasons as which was condoned. I challenge that. Your
Writ petition for these disputes is maintainable, sir.
It is maintainable. Also, contractualized, there is a judgment of the Supreme Court in that regard.
Show me.
And right
Show me
now, I
the
am,
judgment
Your
of the
Lordship,
Supreme
I can place it on the next stage, Your Lordship.
The commercial dispute, even if one of the contracting parties is Article 12,
I have a judgment in that regard, Your Lordship.
basically a contractual dispute.
Your Lordship,
we have dismissed his application on the ground. He has a best case possible that there is an Article 14 violation. This is what the best case he may have, but it is not his case made out in the what the judgments not he's citing is that all that if there is an Article 14 violation, contractual matters can be interfered with. What on the ground that we have dismissed his application for consideration is that he is admittedly he is a defaulting lessee. Now from in 2025 to 2005 he was allotted the plot and the lease was granted. Now we are in the 2025. Even after that, if we show indulgence to him, this will be an Article 14 violation on our part. And this order, my lord, has been carried in appeal.
The comprehensive plan that was set aside. Also, their resumption was set aside, and the court
File a suit
directed.
for specific performance.
Your Lordship, I can.
That they have agreed.
Your Lordship,
Then they are not doing. There was an agreement.
Your Lordship,
File a suit.
Your Lordship, it's on a point of law. I can place judgments. Your Lordship kindly takes it up next week. Just extends and takes it up next week. On this point also, I'll satisfy you.
When this interim order is subsisting.
The end of this.
Actually, the order sought to be, my lord, extended is, my lord, we have carried it in appeal. Appeal is pending.
Because the file could
The
not-
order, my lord, sought to be extended. It's 26th of September order. We have carried it in appeal. The appeal is in pending. Appeal is pending and the matter is listed
Their
before
file
Justice
could not-
Bhattacharya.
Order in appeal.
My lord, my lord.
And no orders have been passed, Your Lordship.
Then
But I've just, my lord, it's my duty to, my lord, indicate before the court. And this is completely an unreasoned order. Only if that the writ petition will become infructuous, that's why interim order has been granted. When there is a complete reasoned order has been passed.
when this order was passed, the lease was the contract was subsisting.
It's a lease
Yes,
between
it
the
was
parties.
subsisting.
Yes, lease has not yet been determined. We have issued a show cause notice that why it shouldn't be determined. He has challenged that.
But they have.
File a reply, let a decision be taken.
Lordship, the thing is that their order, they specifically stated that you're not entitled to it.
Show me that order. Where is that order?
Page number 212.
211.
It begins from 212. Earlier round of litigation, his case was at natural justice violation. So we have provided him an opportunity to show cause.
No, this is the order you are challenging.
Yes, Your Lordship, at 211 it starts, 212 is the order.
No, this is not the show cause.
But by this order, we have directed him to show cause.
Your Lordship.
Where is that?
It's at page number.
Your Lordship, they cancelled our.
Page number 217.
This honorable court had directed to only look
The
into
third paragraph from the bottom. In view thereof, the comprehensive plan is being considered.
What remains after this decision has been taken? What remains? You have finally decided the matter.
Lordship, the case
The
is
scope of issuing a show cause notice.
Lordship, the case is that I just indicate.
You have made up your mind.
I'll just indicate that initially there was a show cause notice issued in 2011. He didn't reply. In 2021, he replied and says for such and it was a clause that within 3 years you'll have to complete the construction, which he didn't. Admitted.
You have decided.
In 2021, we issued a show cause notice.
Yes.
In 2011, 2021, he replied. And in 2021, he replied, we said that now we'll resume the land. He approached this Honorable High Court for the first time and he was granted a liberty to file a representation. Representation was filed. We said that you may come up with a comprehensive plan which we may consider. Now he comes up with a comprehensive plan. The comprehensive plan was being taken up. We have been decided that we are not inclined to accept his comprehensive plan. In the meantime, the Urban Development Department has passed a notification saying all the defaulter lessee, we should resume the land from the defaulter's lessee after providing them a show cause that why it shouldn't be determined.
Where is that?
No, that is not disclosed in the writ petition. I have the copy of it.
No. Where is that disclosed in your show cause notice?
No, it's there.
Show me.
It was there in the earlier round of litigation and here also.
So show me that.
But it's at page number 216.
Yes.
216. It begins from the findings made above.
Yes.
And the submissions made in course of the hearing by the lessee are far from the concept of approving the comprehensive plan, and the commencement of commercial exploitation could have been commenced more or less 20 years ago. That is the period when the deed of lease has been executed. Since the lessee woke up from their slumber at a belated stage and as a commercial exploitation has already been commenced with construction of the existing commercial structure and facilities, there is therefore appears to be no scope of grant any remedy in favor of it.
Taken a decision.
My lord, thereafter, my lord.
What is the use of the issuing this? Decide the show cause without considering the findings rendered in this order? Well and fine.
Here, my lord, it is written, my lord, that the UDMA, my lord, notification has been given.
You have rendered all your findings, then asking him to show cause. It's a predetermined mind.
Because we are left.
Decide this issue with a closed mind.
Difficulty is that we are left with no other options because we are the parastatal under.
Mr. Chatterjee, where is the purpose of this show cause?
I understand. Because earlier round of litigations, what has happened?
Decide this show cause, do that without being.
If I may, kindly your lordship comes to page 179. 179. This was passed by the authority in terms after the initial round of litigation. This was passed. At 178, the order starts February 28, 2020. The specific part is your lordship 179, page 179.
Yes.
The second paragraph. Your lordship, and whereas after considering the hardships faced by the concerned writ petitioner, like the effect of demonetization resulting in financial crunch along with pandemic occurred throughout the country on account of unprecedented COVID-19 as mandated.
This comprehensive plan was directed to
submitted. They had said the writ petition is hereby directed to submit one comprehensive plan regarding utilization of the leasehold land within 1 week from the date, failing which the order dated will be set aside. Subsequent to that, we submitted the comprehensive plan. After submission of the comprehensive plan, they did not do anything. After a few, we gave multiple reminders. Thereafter, they again gave us a notice of hearing, and then they decided to again resume the land on the same terms that we have not worked for around 20 years. We challenged that. On challenging that, at page 194, your lordship.
Yes.
At page 194, this the honorable coordinate bench set aside that notice and directed to only consider the comprehensive plan. It considered everything that they had submitted, even the notice. This 190. They did not challenge this.
Show me where it was directed only to consider the comprehensive plan.
It was directed to consider afresh.
At page
290 रे देखो. Page number 205.
It starts at
relevant portion.
Page
205, my lord, is the relevant.
209, paragraph 36.
My lord, the reasoning is bringing from 205.
This is before directs to give a fresh opportunity over the comprehensive plan. That was only the scope. You could not have traveled beyond that.
Actually, we have said comprehensive plan we are not accepting. The reasons for non-acceptance is 1, 2, 3, 4 that we have enumerated.
Reasons of the earlier decision.
My lord, we have not
was set
condoned.
aside.
We have not, no, that we have not, it was not this set aside.
Comprehensive plan, because earlier that was rejected. They were asked to submit a comprehensive plan. You have asked to submit a comprehensive plan. That they have submitted pursuant to your order. There was no use. Can you now again fall back on the earlier one? What was the ground directing them to submit a comprehensive plan? And now you reject that plan by taking note of the other grounds.
Worship, I had taken these points in the earlier round of litigation, my lord. Let me kindly allows me. Today, my lord, the matter, my lord, because it was not served, my lord, with notice, my lord, I have not armed with the judgments. There cannot be any promissory estoppel when public interest is involved.
It's not that. Two things is troubling me. First is whether you could have traveled beyond the order of the coordinate bench. Second is, what is the purpose of the show cause? When you have already determined or you have already expressed your mind. If you say yes, without being swayed with these observations, I will decide, I will set aside everything, and I will give them an opportunity to file a reply to the show cause. You decide afresh, but without being influenced by the other observations.
Worship, I follow, not sure what follow, but kindly allows me to answer these two queries. Firstly, the comprehensive plan has
All right,
been.
so, extending the interim order, Ashwin, the interim order.
Mr. Ujjwal Rai is appearing, man. He's on lecture court number 1, man. May this paper short pass one.
Who is appearing for the state? Have you served? Who is appearing?
The editor service.
When have you served? Have you served upon the GP?
Yes, madam.
When?
No, it is on 26th. 26th.
26th November.
48 hours, madam.
48 hours notice is today, we are on 28th.
Yes, madam.
48 hours is over.
48 hours.
Then what is happening? All right, not today. Please ascertain who has been briefed. Yes. Next.
The petitioner's land mallet as acquired by the authority for national highway for the PWD. The petitioner's father mallet purchased mallet land mallet 6 decimal rupees mallet 4 lakhs 5,000 for 6 decimal. That is 67.500 per decimal. Thereafter, again petitioner in the year 2018. Thereafter, petitioner's mallet purchased 10 decimals along the same plot of land and 6,75,000. That is per decimal 67,500 per decimal.
Yes.
Thereafter, 2022, the land mallet gifted the 6 decimals from his father. That is the market value mallet 4,86,000. That is 81,000 per decimal. If you lordship, then my lord, the authority, thereafter my land has been also recorded in my name.
Yes.
That in 16/7/2025, my lord, the authority issued a notice. The land value, my lord, fixed, my lord, 5,83,922.
Page.
Page, my lord, if you look
40.
page 40.
Yes.
Page 40, if you lordship. The petitioner's land, that is, my lord, 12% interest and solicitor,
Yes.
my lord, yes. That is of say 5,83,000. 5,83,930. 930. That is page 40. Thereafter, my lord, I made objection before the authority concerned. That is page 41.
Yes.
That the as per market, I have purchased the land for more than 10 lakhs something, my lord. But assess the land, my lord, 5 lakhs something. I say, my lord, the market value will be decided. That is the recent law also there, Act my lord 13 if a lordship. That is fair compensation and transparency land acquisition of Rehabilitation Acts and 13.
Yes.
The market value 26 if a lordship, the market value will be decided.
Yes.
That's about the authority concerned. The collector is the authority to decide to assess the said market value.
Yes.
Finally, direction to the authority concerned to assess the market value and consider my depreciation within a specific period.
My lord,
No, if you are
award has already been passed.
Award has been passed by whom?
By the competent authority.
No, then if he is aggrieved, he has to approach the arbitrator.
Arbitrator 3G5. He has not approached. He has to go to the under 3G5.
Sir, you have a remedy under the
comprehensive remedy.
You are not satisfied with the award of the competent authority. You have to keep hujjan. Copy of the National Highways Act.
3G5. Subsection 5 টা পড়ো একটা বই আছে
Who is the authority? That is the assess kindly see
arbitrator.
Page my lord, authority my lord.
Yes, competent authority.
Who is the arbitrator?
Competent authority.
Who is the competent?
No, competent authority arbitrator has been notified. Who is the arbitrator?
In generally, the district magistrate is the arbitrator.
I have also made objection.
Not you have to objection. You have to
that
award has been passed. You have to say that this award has been passed. I am not
District
satisfied.
magistrate has passed this order, Mr. Mahato.
My lord.
Page 40 is by the district magistrate.
My lord, as a competent authority.
So arbitrator, can it be district magistrate?
No. In this case, my lord, arbitrator will be the commissioner.
I think so.
The commissioner, it should be commissioner, my lord.
Yes.
And 7 says, my lord, 7A, that is the market value will be decided.
Yes,
That
yes,
will be
market
there,
value.
because if you are agreed by that, according to them, this is the market value.
This is the-
According to you,
That
this is
I
not the
purchase-
market value. Yes,
I
market value has
purchase
to be
more than
higher.
10 lakhs something.
You have to place your
In
case
two- in
before the
2018.
arbitrator by relying
Who is
upon
for the
the
national highway? National highway, have you served?
That is still.
no, National Highway Authority.
National Highway Authority is not the state.
Executive engineer superintendent.
No, Highway Authority. ন্যাশনাল হাইওয়ে অথরিটিকে তুমি পার্টি করো নি তো
The petitioner claims I've given you liberty, you approach. I've not fixed any time limit. Yes.
My lord, I am appearing on behalf of the petitioner.
No, I'm here for the respondent number 2 and 3.
2 and
3. Port.
port. Inaction on the part of the port.
No.
Then
It is the land was acquired by the state.
you are the requiring body.
Yes.
Now what happened?
They are saying.
All right. Yes.
My lord, I am the owner, joint owner of my lord, plot number 239 of Moja Choktaron Holdia.
Who is for the state?
I served.
When?
My lord, last week.
GP you have served.
Sir, my lord, I have given affidavit of service.
So, Mahato, what is happening? Please inform. One day I called the government pleader and I told him.
State is.
Then I will do one thing. I will not engage anyone. I will pass ex parte orders. If this is the attitude, then I will not engage anyone. I will pass ex parte orders. What is happening in none of the matters? The state is being represented.
Well, state is required, my lord, here.
Yes.
My lord, I am the owner of the freehold land of 25 decimal pertaining to RS Dag number 239, my lord, in Holdia. My lord, suddenly what happened?
Suppose can you appear in this matter?
I can appear.
You can appear, all right.
Only suddenly what happened, my lord, some people claim to be the part of Haldia Port Trust, my lord. They are constructing boundary wall around my plot of land. My lord. That is not, I came to know that that is not, my lord, or whether they have not informed me about any section 5 notice. But I have got nothing, my lord, and it is not a part of any acquisition process, my lord. It is a freehold land, my lord. They are constructing boundary wall.
Who is constructing?
My lord, they are claiming to be the Haldia Port Trust Authority.
I'm fencing the boundary wall, entire land acquired by me, acquired by the state that was given.
My part is not acquired.
Plots have been acquired.
That is 193. 193 has been acquired. Entire land, my lord, has given to the port. Port
What
has.
is your plot?
239.
239.
Yes.
239.
Well, that has been acquired. 239 by notification.
239 acquired.
Yes, yes.
But I have no.
But that
no
area,
about any-
Chokrabaria area, jail 193, Choktaran area, jail number 190.
Show me where is the notification.
Notification, well, that state has to. I don't have it.
My lord, I have prayed for several times, my lord. I have
No.
from pillars to post.
He has
to
nothing
know
spelled in the
whether-
writ petition. Nothing has been spelled out about this.
My lord, I have given a representation also.
No, he has
before
not said
coming
that.
here.
What is your name?
My lord, my name is Bhaskar Parui. And my lord, I am owning this land, my lord, along with my brothers and sisters. It is an inherited property.
So far, my remember, this
It is the
Bhaskar
name of
Paroi,
my father.
he also filed a writ petition long ago for land loser candidate. Land loser candidate for appointment. So far, I remember that is not with me. It is around 1992. So his land was. But notification is with me, my lord, one notification.
All right, then let them file a report. File a report.
My lord, may I humbly submit, my lord, till then, my lord, and my lord, they are doing one thing, my
Till
lord.
then what?
My lord,
No.
there is
From entire land, I have making fencing the boundary wall.
If anything, if it is found that your this property has
been acquired.
has been acquired, you are entitled to compensation.
Compensation.
If you are not, if it is found that your property has not been acquired, the writ petition will be kept pending. I will direct them to demolish.
Yes.
Take it out of
And
the.
my lord, they have
I'm
damaged
making
the adjacent
fencing
road,
boundary wall
They have
out.
damaged the adjacent
Entire
road,
land.
my
Mr.
lord.
Jana, if his property has not been acquired, you cannot.
How can I make a boundary wall?
That is.
How can I?
If it is found that his property has not been acquired, so you have to remove.
They have to say even whether award has been passed or not. They will say.
No, award is a different.
Award is another thing.
Award is another thing. Whether it is the subject matter of acquisition.
Acquisition, correct.
If it has not been acquired and if it enclosed another plot,
No.
then
No, that is absolutely not
then
correct.
you have to hand
No,
over
no,
possession.
yes.
Humbly submitting another point, my lord, pointed out by my client, my lord, there is a concrete road adjacent to my plot. That is the only way for ingress and egress to that plot of land, my lord. They have completely damaged it. They have completely damaged. I'm unable to go there.
All right, without report, it cannot be anything. Cannot be said.
Jail number 193. Jail the notification is here.
Where
Jail
page?
No. It's a document. Maybe let's look at it. Don't ignore the other document, my lord. 193 jail number.
Plot number.
Jail plot.
Plot number.
Subject to correction, my lord, what they will say, whatever the document with me.
No, this is only plot number 971, not the entirety.
That is not in entirety, my lord. That's why I was trying.
I will bring the northeast corner only of.
Then other notification, maybe.
Jurisdictional list, it does not say that you have.
No.
Jurisdictional list.
Because I have paid the compensation. That's why I'm telling.
But here it says.
Maybe they will clarify.
Only northeastern corner, not.
Let them file a report. My lord, I will consider.
The আচ্ছা একটা মিস্টার জানা প্লিজ there shall be
The husband of the petitioner was the owner of a particular plot of land. Now, in 2011, an acquisition proceeding has been started for extension of NH12. The land of the husband of the petitioner was acquired, but the compensation was disbursed in favor of somebody else.
Compensation?
Disbursed in favor of somebody else. Now, the husband of the petitioner lodged a complaint before the competent authority, and competent authority passed an order that is at page 38. Your Lordship, kindly straightway come to page 30. The ordering portion is at page 39. Last paragraph. At the submission of both the parties, all material records, other documents are consulted. It is there.
What is your name?
But I am the wife of.
What is your name?
I am the wife of Bishwajit Basu. This order was.
Yes, Mr. Mahato, you know,
Yes, my lord,
you have admitted this.
Admitted, my lord. We have to it, my lord, but we have to, my lord, refund back, my lord.
So refund back.
Have you implemented those persons as parties?
They have not.
They are, because we have to refund. We have wrongly paid to, my lord, the earlier recorded.
Recovery is their part. They will recover, but I cannot be
Where
suffered.
his name recorded? No.
No, but earlier recorded owner, but he on material on record that he has transferred the land and he petitioner is entitled to. That is the finding.
The order of the competent authority. The order
14 my lord, I am appealing for.
You know, time for this respondents.
Yes.
And I am appealing for.
Yes.
Sir, this is the second round of petition. You kindly come to page number.
First round, the clients do not come to you. It comes in the second round.
No, first round also. The client.
Client came to you.
Second round.
Yes.
Kindly come to page number 33, my.
33.
The order passed by this court. By the Honorable High Court.
Where is your senior? He's not present. Other court. Yes.
Kindly.
To consider a copy of the writ petition as a representation?
Yes, well, kindly come to paragraph number 8, man. That is on page number 34.
Yes.
Considering the rival submission of the learned advocates for the contending parties and on careful perusal of the entire material on as placed before this court while disposing the instant writ petition, direct that respondent number 3 to obtain the field verification demarcation report from.
Yes, what happened after that?
Thereafter, order the special land reform special.
Page 41.
Page 41.
Demarcation
made, but my lord, the BLR report has not been served upon the petitioner.
Yes, then what has been done?
My lord, thereafter, my lord, kindly come to page number 42, my.
Yes.
Page number 42 from the top. From the report, it is found the suit plot number 27, 32, 35, has been actually been utilized.
What is your plot?
All these are my.
All these
are my. Partly utilized by the PWD road for the construction of road. The above mentioned plot, except plot number 696 of Moja Sajansa, have never been acquired in acquisition case. Those land has that never been acquired. Thereafter, the plot number 696 for partly requisition in case number such and such, and possession has been handed over to the requiring body. The subintending engineers.
Yes, Mr. Ghosh, what is
Milord, as far as this matter is concerned, Milord, I have received this brief today in the morning. My telephonic instruction is that, Milord, the State Highway Planning Circle, Milord, have already placed the matter, the proposal, Milord, to the PWD LA administration, and Milord, for further course of action. And Milord, now the respondent number 3, Milord, they have requested me, Milord, to take some time to come back with a report.
What report?
That what steps have been
You have
taken.
to pay compensation.
My lord.
Without initiating any requisition, any acquisition process.
Whether, my lord, the process of payment.
How are you constructing the roads?
The road has been constructed in 2006.
My lord, I have understood, my lord. For that, my lord, kindly grant me a week's time, my lord, so that I can come back with instruction in connection with the compensation.
One more thing, my lord.
Because the
My lord, any date except the next Friday, my lord, 5th, any day.
My lord, one more thing, my lord. That is kindly come to the last paragraph of page number 42.
Yes.
Now, for the further compliance of the order dated such and such of the Honorable High Court, the Superintendent Engineer State Highway being the appropriate office.
That is why he is
That part has been dealt with. That part has been dealt with.
How much time it will be within how much time?
The compensation has to be paid according to 2013 Act, but it has been.
Let him come with the instruction. He has not said it will not be paid according to 2013 because no acquisition proceedings was initiated. So now it has to be under 2013 Act.
Yes.
Let the report come.
Yes.
Ghosh knows that. That is why he said,
yes.
I will be filing a report. Yes. Special land acquisition.
My lord.
When?
3, respondent number 3.
The petitioner, the learned advocate
Your Lordship, I appear for the state in this matter. I appear for the state in this matter.
State.
My lord, I am for the petitioner. I am led by Mr. Shobhosati. He is out of session. I paid for not to.
You are led by?
Shobhosati Chatterjee.
Official demarcation of LR plot number such and such. It's your own plot.
Yes, Your Lordship, private dispute, there is a private
How can it
dispute.
be demarcated by
Title
the
suit is
PLR?
pending.
A private property. Under what provision of the Land Reforms Act?
And Your Lordship, title suit is already pending. Title suit is pending.
Title
Over
suit
there.
pending.
Yes, Your Lordship.
Title suit is also pending. Where is Mr. Chatterjee?
He is in Delhi.
It prima facie appears to this court that
Item number 1.
civil division dismissed. একটা মাত্র দেখুন।
To murder application, sir.
What is that report?
Report.
Mr. Mukherjee, have you served a copy upon them?
Yes.
They gave the copy
When?
on 26.
You have gone through the report?
Yes, sir.
Dinto?
The can you see page 6? Deed was executed.
But not in the name of original property.
Yes, Mr. Mukherjee.
Kanai Rai.
He is not the original plot holder.
Then please wait.
Yes, on the can you see that this deed was executed.
Page.
Page 6.
Yes.
Executed.
Page 6.
Page 6.
Of the
report.
Page 6 is
Oh, sorry, page 8.
guideline. Oh, there are 2 page numbers. Yes, page 6 is the allotment of plots. Yes.
Page 8. And
it's in the name of Kanai Lal Roy.
Kanai Lal Roy.
Yes.
And then can you see page 12?
Yes.
With reference to his prayer dated 20.
So what is the dispute, Mr. Mukherjee?
But according to them, they have not received the possession.
No.
Who are they? How they are related with Kanai Lal?
Page 16 for a moment.
Yes, page 16.
This is a name. It seems that
The old title deed was issued in favor of Kanai Lal Roy.
Right.
And Srimati Bijoya Roy.
Bijoya Roy.
And as per Convict Register, freehold title deed was issued to Kanai Lal. Now it seems that the Brojendra Lal and Brojendra is the same person. Yes, what is the dispute? What is their claim?
They are claiming that they have not issued the.
They have?
They have not issued. Madam, kindly see the deed.
Sir, can I say something?
Yes.
Original plot holder is and was Rabindranath Rai. So the deed was not
Original plot holder was?
Rabindranath Rai, Sri Rabindranath Rai, my grandfather. And the deed was not issued in his name without any NOC and nothing. He has never given any NOC. According to their report,
Where
as
is
it
the
is not.
document to show that he was the original allottee?
According to my petition, it is in annexure number 1, and according to theirs, it is annexure number 4. Annexure number 4.
Yes, Rabindranath Roy.
Yes.
So he was the original allottee.
Yes, yes.
And free title deed was issued in favor of Rabindranath Roy.
No. No.
Not issued.
No, it was issued in favor of Kanailal Rai and Vijay Rai.
Yes, Mr. Mukherjee, it seems that it was in the name of the original allottee was Rabindranath Roy.
No,
Yes, sir.
but
How could you issue a freehold title deed in the name of another person? Because it's your document, page 14 of the writ petition.
Madam, kindly see page 3.
Page?
Page 3.
Of your report.
Annexure R1.
Of your report?
Yes. Madam, kindly see, as per available official records, Sri Rabindranath Rai, son of late Bojendra Raja, was the original plot holder of
Yes.
enumerated plot number 575 and survey number plot number such and such of Sri Colony. Issue of deed lease file is not readily available. However, freehold title deed is issued for in squatters land by following GO number such and such, dated 1981, on the basis of effective possession of the land and maintaining land. Freehold title deed was issued for plot number enumerated plot number 575 and survey number plot number 680 Colony in favor of Kanailal.
This Kanailal and this Rabindranath, they are
Yes,
two
it is.
brothers.
Yes. Two brothers.
Mr. Mukherjee, as per your document, allotted in favor of Rabindranath Rai. So how could you issue in favor of Kanailal Roy?
If the mistake has been committed, Madam, kindly see when the deed was registered.
You have committed the mistake.
Madam, that is in 1988.
Maybe.
But
Madam, how could be corrected here after 40 years?
Mr. Mukherjee, it's for your mistake. A party should not suffer.
No. For 1988.
তাতে কিছু না তো, আমরা জানতামই না।
We never knew about the matter.
After survey,
Kanailal has been made a party here.
He is dead. He is dead in 2000. 2012.
on survey, Kanailal was in
No,
possession.
Sarve Rabindranath Rai was found because he is the original plot holder.
Have you
But how that
implemented
could be
the heirs of
decided?
Kanailal? Please deplete the heirs of Kanailal.
কেউ নেই।
Kyun nahi? They are dead. They are deceased.
Mr. Mukherjee, who is now residing there?
They sold the
Then inquiry has to be conducted.
তারা জমি বিক্রি করে দিয়েছে।
তারা জমি বিক্রি করে দিয়েছে অন্য লোককে।
When it is not for the government.
দিয়েছে, ফ্ল্যাট তুলছে, উল্টোপাল্টা হবে, ফ্ল্যাট
And how can
How is the
88,
the question?
88, assuming for a moment,
Kanailal Rai and Vijay Rai. That's the
assuming for a
question.
moment that there is a mistake.
Decided there.
Both of you, then I cannot take. I'm releasing this.
Sorry, sir. Sorry, sir.
Assuming for a moment that there was a mistake on part of the government in 1988, how could be corrected in after 21?
You have committed a mistake, Mr.
No.
It's your document which says that it was Rabindranath. How
On the basis of the survey,
Kanailal?
on the basis of the survey, who was in possession? There is a government circular.
Where is the survey report to show that who was in possession? Yes, how long it will take, Mr. Mukherjee?
The government circular at page 4.
দুটোর সময় আপনারা আসতে পারবেন না, অন্য কোনো দিন সুবিধা হবে?
দুটোর সময় আসবো স্যার, দুটোর সময়।
Mukherjee, come at 2 p.m. because I have a bench at.
Oh, sorry.
ঠিক আছে।
None appears for the. None appears for the appellant.
Item number 60,
Same order.
item number 61,
Same order.
62,
Same order.
63,
Same order.
64,
Same order.
65,
Same order.
66,
Same order.
67,
Same order.
68,
Same order.
9,
Same order.
70,
Same order.
71,
Same order.
22,
Same order.
23,
Same order.
24,
Same order.
25,
Same order.
26,
Same order.
27,
Same order.
28, 79,
78. 70. Same order. Dismiss for default.
80,
Same order.
81,
Same order.
82,
Same order.
83,
Same order.
84,
Same order.
85,
Same order.
86,
Same order.
7,
Same order.
58.
Same order. Hold on. Yes.
Item number 17,
Pass over next.
item number 18,
Who is for the petitioner?
Orijit Bera.
Pass over. Pass over next.
Item number 19,
Praying for a short Passover.
Pass over.
item number 20,
Pass over.
item number 21,
Will I appear on behalf of petitioner, my lord? Here in this case, my lord,
Who is for the state?
Mr. Darik.
Darikanath Mukherjee.
Yes.
Where is
Well, he was here, well, just my lord here, left this
Here
passport.
outside.
No, my lord. This is Bahar most probably.
Pass over.
Pass over, my lord, after 2 p.m. My lord.
item number 22,
Pass. 22. You are appearing for the state. What do you want?
My lord, the
Petitioner is not here.
let the representative be considered, my lord, because he was once upon a time, he was willing to give the land. On the basis of that, my lord, that promise, my lord, we have also built the, my lord, my pump house on his land. Now he is claiming that I should be given the compensation as well as appointment. Although he has been given an appointment.
Pass over. Yes.
item number 23,
Pass over.
24,
Pass over.
25,
I'm
for the
You are appearing?
Yes, Lord. So I've shoved the copy to the other sides. This is the affidavit
For
service.
the state.
So,
Pass over. Yes.
26, Your Lordship. I'm for the private respondent in this matter.
Pass over.
27.
Pass over.
28.
But I am for the petitioner in this matter.
State.
The state, Mr. Day is appearing for the state.
Pass over.
29.
29.
The private respondent is there.
Yes,
There. Who is for the private respondent? Then pass.
Then
otherwise
password.
Yes.
Password
for the
No,
No. After
29.
2 p.m.
28.
Yes. Why?
Oh, দুটো
Not
একসাথে আছে।
available from 2.
দুটোর পর আসবেন তো? But after 2, then it will be called on again.
Just because
Yes, yes.
of 1
No.
PM.
No.
Yes.
3:30.
Item 30.
3:30.
3:30 is there.
Today 3:30 is there.
Pass over.
Item 31.
Pass over.
32.
Pass over.
33.
Pass over.
34.
Pass over.
35.
Pass over.
36.
Pass over.
7.
Pass over.
38.
State Lordship, 37.
Pass over.
39.
Pass over.
40.
Pass over.
41.
Pass over.
42.
Pass over.
43.
Pass over.
44.
Pass over.
45.
Pass over.
46.
Pass over.
47.
Pass over.
48.
Pass over.
49.
Pass over.
50.
Pass over.
51.
Pass over.
2.
Pass over.
53.
Pass over.
54.
Pass over.
5.
My Lord, I am for the petitioner.
Pass over.
26.
Pass over.
57.
Pass over.
58.
Pass over. You are not there, what can be done? I have not dismissed your matter. Any matter where all sides are present. Any matter where all sides are present.
And in 55, my lord, petitioner and school are present, my lord.
Any private party is there?
Yes.
And the private party, school.
You are the private respondent. Who is the petitioner?
My lord, I am for the petitioner.
And who is the state is there?
State is also
Present required.
required, my lord.
Who is for the state?
Shoibalindu.
এটা কি আছে না আগের থেকে?
My lord, board, Koili Bhattacharjee, Miss Koili Bhattacharjee appearing for the board and probably Mr. Shoibalindu.
Their presence is required, my lord.
No, if all the parties are here, I can take it up. Otherwise, at 2 p.m.
ফোন করতে বলো পরেই করবো
Very well, let it go. No, 2 p.m, my lord, I have some difficulty at 2 p.m.
তাহলে টাইম চাইতে বলো কাউকে একটা যখন ডাকবে
ঠিক আছে, সেটা হতে পারে। 2 p.m or next week, your lordship, if your that subject lordship's convenient.
Item number
Is the
55.
petition?
55.
Your lordship will take it up today at 2 p.m. I'll be.
যদি না প্রথম থেকে কল হবে
Oh, from the beginning it will be called again. From the beginning the list will be called again. Then, my lord, I'll try to appear before lordship. 3 matters are fixed at 7:59, my lord. I'll try my best to come before lordship. In case I can't, my lord, kindly accommodate.
Keep any of your juniors.
Yes. I'll try to, my lord.
পাসওয়ার্ড পরে হবে
I can refer one. Victor, before the writ petition, my lord, there is an application my lord, for extension of interim order, enjoying an order of interim order, my lord, it's expiring on Sunday, my lord, the last day of the month.
Lordship, may I subject to your Lordship kind consideration?
Yes.
Your Lordship, I am opposing the prayer for extension of interim order. If your Lordship kindly see the principle, the interim order which was passed against the bank was ex parte. It was ex parte order. And Lordship kindly see the prayer.
Apply for vacating also.
Lordship, I'll leave it to your Lordship. But my predicament before your Lordship, they are challenging the surfacey action of the bank.
What is the writ petition for? Where is the writ petition?
They are challenging the surfacey action of the bank against which
Certainly not.
a Lordship Debts Recovery Tribunal, they have moved an application. Interim order moved.
What is the challenge in the writ petition?
Lord, I am not the person who has taken the loan. Well, I am the owner of a separate property. Well, I am the one of my son and my brother has taken who is the private respondent. He has taken the loan. He has mortgaged some other property. Well, my property is being attached. My property is being sold, which is not the subject property. It's not the secured asset, my lord. That was the order. It was not the secured asset which has been sold.
Lordship, this is the
It is being attached. It's not the secured asset.
tribunal. One of the
He might have gone to the
private respondent. Brother, please, brother. Private respondent filed an application staying the order of the district magistrate. On contest, that was rejected. So they projected their family members by filing a writ petition to stay the process of execution of DM order.
This interim order is not the secured asset.
What are you challenging?
Well, I'm challenging wrong. Well, the action of the bank, my lord, on the wrong identification of the land.
Are you challenging any order passed in the?
There is a DM order, my lord.
Yes.
For taking police protection, my lord, that has been challenged.
Yes.
And
Which
that
order?
has been stayed.
Which order you have challenged?
My lord, project appears at page 55.
Surface Act আছে কি?
Page 55.
Yes. DM order has been challenged.
Well, I am not a party to this entire.
Section 17.
I am third party. Well, I am not the person who has taken the loan. My property has never been mortgaged. Because on papers they are attaching a separate property and they are on physically they are coming to my property.
Fall within the purview of any person
The order which has been passed.
defined under section 17.
Please give me a minute.
Sir, which in act? The Surface Act. Section 17. Yeah.
Which is your property?
My property, Lord, is tag number, Lord, 188 and 189.
188
and 189. Because I am enjoying order stay on this property. So they don't attach this property.
Yes, it's a different property.
Your Lordship, is such being so, subject to correction.
96 and 195 is the
Yes.
scheduled property. So how can you take another property?
No, I cannot. I cannot go beyond the district magistrate's order. I will act on this. I will act on this.
This is not your property. I am only recording that.
Yes,
Only.
yes. I will act on this. Why operation of the order will be stayed?
Yes, yes.
Lord, the property which they are showing, Lord, kindly have a look at the DM's order. So what are they attaching? Kindly see this.
I'm at the DM's order, page 55.
55, I'll just indicate. But they're saying
Order number 196 and 195.
Not that, and I'll show something else. Where is the play going on? So they're saying the two-story building.
Yes.
Yes, Miller, on this 195 and 196, it's a pond. Well, I can do the two-story building. I can show Miller, there's a survey report to that effect. So it is an adjacent property. That's a pond which has been given to them. And they are attaching the building. There is no building on that land, Miller. I'll show Miller, kindly comes to page 163 of this application. Why this order was passed?
163.
No, only 63. Only 63. Only 63. So can you see 195 and 196? Is there? At the here, Lord, at the bottom. One is used as a pod and bank.
No. Where is the deed of 2613 of 2014? Show me that.
It's not my deed, but it's their deed. It's the private respondent's deed. Well, I don't know what the private respondent has purchased.
Show me your property.
I can show you the sanction plan. I've attached the sanction plan, the documents, my lord.
Yes, show me.
It kindly comes to page 35. This is my, the sanction plan issued by the authority. This is the two-story building standing there on. At the left, at the right hand side, 188 and 189 two-story building only there. These are the 4 plots of land which are adjacent to each other.
All right, I will record that your property is 188 and 189, and they are proceeding 195, 196.
Yes, I will stick to the DM.
I will say what? Well, they can
You
also
do not have any right over 195, 196.
nothing, they can take
Bas.
196.
Yes, yes. I'm only recording
there is
that.
no two-story, there is only one two-story that is mine. They'll break into that property, my lord.
How?
So that is a difficulty. Let it be done at my cost, at the presence of a special officer. Well, I'll bear the cost.
But I cannot go beyond the DM order.
Yes, my lord. Certainly,
This may be recorded.
Let it be in front of a special officer. Well, I will
Why?
be bearing the cost.
I will not go beyond the DM order.
Properties, I have no issues on that. Well, there'll be
Any
special officer.
surface application is pending.
The surface application at the instance of the son of the petitioner is pending for the tribunal. Their section,
Not me.
section 14. Yes.
You apply any person, please.
Yes,
kindly come to
any
section
person.
17.
Definition.
Section 17, any person including the borrower. So you are covered. If you are challenging any action on the 13.4, this comes with the 13.4.
The properties for which they have gone to
What is the problem if you go before the tribunal? Everything in the surface.
the borrower, my lord, not my property is mortgage.
Sir, please see section 17.
I understand.
Even if you're not a borrower, you can challenge. It's any person, it's very wide, sir.
Well, I understand that, my lord. Kindly listen to what I'm going, my lord. Those two properties which they are taking, well, I have no control over those two properties. I don't have any authority to
Sir,
speak
if
in
you
your
have to
word.
challenge, one proceeding is pending.
Well, this is a separate property, my lord.
Maybe.
Separate property, I have to go for the action of
Maybe
the bank.
you are
I'm not a third party.
you are disputing the identification of the property. Please go there. Tribunal is insisting over the matter. It's the best authority to decide whether there is any dispute with regard to identification.
Third party, my lord. Kindly.
The third party also can.
Well, my property is not being mortgaged.
Yes, please tell the tribunal, get it released from that. Saying, get it clarified.
Well,
That
kindly record this submission, my lord, that they are
I will
saying.
record.
I'll just record one submission, my lord. If they are saying that the property which I am saying they are going to attach.
Why
that,
you are saying? I'm stick to the DM order.
saying I'm not going to attach that.
Do you have a copy of the Surface Act?
Well, I don't have it.
Please take it.
Well, I understand that, my lord.
Have you got those line of decisions which has explained the expression any person?
Very wide, your lordship definition. Yes.
The properties which they are trying to attach, there is no such two-story building. Well, they may attach the property itself. If it is a pond, it's a land, whatever it is, they can attach it, but not the two-story building. That's the difficulty. There is no two-story
I
building.
do not know whether it's a pond, whether it's a two-story building or it's a three-story building. I will, this dark number, they will not proceed beyond that dark.
Yes.
I can clarify
Well,
only that.
let that be
I
done.
will not go into two-story, three-story, four-story.
Let that
I
be
will
done.
only take
I don't
action
stand in
in
the
terms
way.
of that.
I don't
schedule.
stand in the
order.
way.
DM
I
order.
don't stand in the way. Will only that will be done in presence of special officer at my cost. But
Why?
Only my
So
cost.
go before the tribunal, apply for special officer, anything. Here I will not allow to raise any dispute as to the identification. If you say yes, there is a dispute with regard to the identification, you have to approach the tribunal, get it resolved there, whether there is any dispute or no dispute, whether your son has a right in that property, you have a right in that property, trash out there.
That property which is been mortgaged.
All right.
I do not have any right.
So they are not taking your property. Your property is 188, 89.
188 and 189.
Yes, I
that
will
protect.
Yes.
Any properties of
I will say, I will not protect any property. I will only say that they cannot travel beyond this 195.
Yes.
I can make only that.
The only difficulty that will remain, below is that there is a two-story property. There is no two-story property.
I do not know two-story, three-story, one-story pond. That I do not know. This is the dark number. I will only clarify that. I will restrain them from taking any steps apart from that schedule of the property which is mentioned.
In terms of the DM order. Oblige, your lordship.
I'm applying for Reserve Bank. No relief.
The
evidence service may be kept on record. In terms of the last report.
Yes. So the main writ petition, that's the only challenge in the writ petition.
That's my only challenge.
Yes. With the consent of the learned advocates for the respective parties, Hmm? Yes, thank you.
Oblige, your lordship, with your lordship.
Yes, call the list.
One request. I seek a stay of this order for a week.
Where is your other side? Place for stay of operation of this order for a week.
1 week.
Lordship, I leave it to your lordship, because I leave it to your lordship.
After this order is passed, the learned advocate appealing for the
রিপোর্ট অলরেডি ফাইল করেছিলাম তখন
Yes, Mr. Mukherjee.
যা ডকুমেন্টস আছে এটাই
Now, who is in possession?
সেটা ইনকোয়ারি করব
Only
হোল্ড আউট ওই প্রপার্টিটা এদেরই
that information I have not.
they are saying
Yes,
it's already sold out those who desire sold the property those who desire sold the property
To whom she has.
his cousin brother and her mayor
You have to implead them. You have to implead them, the persons who are in possession.
they are constructing right now
Implead them. Without impleading them, how can an order be passed? Who are they? When they have sold, have you disclosed in the petition?
yes
Where?
page number 9
9.
from 8 to 9
Your cousin means he is the son of.
Virendra Tondura.
mutation and
Yes.
done so how it is possible
Now, Mr. Mukherjee, have you executed a deed in their favor? How could this be transferred to another person?
Kindly see, the policy at page 4.
4 of your report. Yes.
Who is in possession, that would be this deed would be executed.
Whoever is in possession. So you have ascertained the possession at the time of
Execution of the deed.
Have you said so in the report? Where is that?
April 1987 this is
Where is the report?
paragraph number
The report টা কোথায় গেল?
47 years ago at no present records available as a further plot of
No, it is judge.
Yes. Page 4.
Page 4, 20th April 1987. Policy of the government. Guidelines. Pre-51, pre-71 and post-1950.
No, this is a guideline of 1987, 20th of April 1987.
87, yes.
Where is that? Which paragraph says so?
Kindly see page 5, paragraph 5, 115. But lease deed has been executed or lease deed has been since expired, the serving members of the family on record may produce succession certificate or the alternative to an affidavit if they are heirs of the deceased holders and are maintaining possession of this property. The eligibility case could be determined on the verification of the contents of the
This is after expiry.
expiry.
First paragraph, the following.
Declaring
Declaring the decision to give freehold and permanent title deeds to the occupants. Page
Okay,
number 4.
can you see page 4 for a moment?
So land,
Yes.
first paragraph.
First paragraph.
The government of West
Yes.
West Bengal is the refugee data, declaring the decision to give clear land, creates to the
Four. There
occupants
are
of
many
the
page numbers. Which page 4?
page 4,
Mark
page
card,
4.
mark card. Page
There are two
Mark-
page numbers.
page
Right hand side, right hand side.
mark card.
Page 6.
No, page 4. 20th
With
April
mark card.
1987.
20th April. Yes.
Can you see the government of West Bengal in Refugee and Rehabilitation Department issued government order bearing number such and such dated 10 November 1986 declaring the decision to give up cleared land and permanent lease deed to the occupants of the DD colonies situated in urban Midway. Occupants. That means who is in possession?
No, Mr. Mukherjee, but this document, please kindly come to the writ petition. Writ petition, this was on what basis? This must be on possession. Page 14.
Just give me 1 second.
Was the original plot holder. So at that point of time, he was in possession, Rabindranath Roy.
Yes, sir.
Page 14 of the writ petition.
Yes.
So,
That as per affidavit records, Rabindranath Rai, Rabindranath original plot holder, deed was issued to Rabindranath Rai, serial number, plot number
so this is
575.
EP number 575 and SP number 693.
Yes.
So if Rabindranath Roy was the original plot holder and the title deed was issued in his name, how could that be changed to another person?
No, that's one of the only difficulty is this records is not available.
Mr. Mukherjee, this is your document.
No, about 40 years back.
Mr. Mukherjee, this is an
number 7.
information
Return.
which you have supplied in the year 2024. Must be based on some documents of in your office. How could you supply these records then?
Measure of
Cannot say that these documents are not available.
The undersigned is directed by order of the government to say that as a measure of rehabilitation of this.
Where are you reading?
Page 7.
Page 7 of your
report.
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 Yes.
The undersigned is directed by order of the government to say that as a measure of rehabilitation of the displaced families, homestay plots where are being allotted as GS colonies or squatting in approved quarters colonies are being regularized with the clear intention the beneficiaries of such allotment will be all members of the family. On record through the allotment order was issued the name of one of the members of the family as Korta or de facto head of the family who might have been eldest brother or else as per composition of the family as recorded at the time of allotment of the plot.
Yes, I follow Mr. Mukherjee. Please kindly come to page 14.
Yes. 14.
Page 14 of the writ petition.
Yes, I'm pretty.
Now, it's an information supplied by you,
Yes.
your office. Now, it says with reference to the prayer dated such and such as per available records. So, you have the records saying who Rabindranath Roy was the original plot holder and free title deed was issued. Now, how could that be modified subsequently? Where is the link?
It was wrongly mentioned.
You are silent on that.
Can you see
Mr.
page
Mukherjee,
14
you have
of
not
our report?
pressed.
No,
Mr.
no.
Mukherjee, you have not
There's a
pressed from
corrigendum. There's a
Rabindranath Roy.
corrigendum. There's a corrigendum.
Page?
Page 14 of our report. 12 February 2025.
This petition, his petition.
Rajeshri Rai, address to Rajeshri Rai.
Yes.
12 February 2025. Corrigendum against
This is the same document.
Yeah. Page 14.
No,
Yes, page 14. This is the same document. You have taken from his page 14.
Of our report. With reference to the subject matter, the PO deed was issued in favor Kanailal Rai, son of Bajendra Rai.
Where?
Report page 14.
Report page 14.
Page 15. The
14.
pages are not telling, Mr. Mukherjee.
14.
No. 14 is the same document which I referred to. That is at page 14 of the writ petition.
Just give me one
15. Free title deed was issued.
19 February. No, it is a 12 February.
It was wrongly mentioned.
12 February 25. 12 February 25.
12 February 2025. With a reference to the subject, but kind of agenda against reply dated 29 February 2024.
Memo number 28 CDR.
19 December 2024. That is page 14 of the writ petition. With the reference to the above mentioned that freehold deed was issued in favor of Sri Kanailal Rai, son of
Mr. Mukherjee, produce the entire records.
Produce
Produce the entire records. Now you are saying by mistake we have said Rabindranath Roy.
Whatever the records available, I'll certainly.
Not whatever. These two documents are there. From where did you say Rabindranath Roy? You did not have any document.
It was wrongly mentioned.
Please produce the record.
You can't say that.
And in the next
It was
corrigendum, now you
wrongly
are
mentioned
saying.
at Rabindranath Rai. It was wrongly mentioned at in
Yes.
place of Sri.
How could you say so? How could you say so? It was wrongly recorded. You have said title deed. On what basis you supplied this information? It's very easy to say it was wrongly stated there. Produce the records.
এইটা দেখুন পরের পেজটা দেখতে বলুন এটা দেখুন এখানে পরিষ্কার লেখা আছে রেফারেন্স টু দ্য ইস্যুড ডিড ফ্রি হোল্ড ডিড কানাইলাল রয় এন্ড বিজেতা রয় এটা পরেরটা দেখতে বলুন পরেরটা দেখতে বলুন পর দেওয়া আছে কিভাবে করছে আবার কি পর আছে এটা
And another letter.
Your title deed in the next corrigendum, it says in favor of Kanai Lal Roy.
পেজ 15 আছে
It was wrongly mentioned Rabindranath Roy in place of Kanai Lal Roy. Ashun. Yes.
ওই জায়গাটা চলে যান গিয়ে জেনে নেবেন।
Yes.
I am for the Union of India.
Yes. Where is Mr. Vahan Banerjee?
Well, he is engaged before court 4 Milos, so I'm praying for short Passover.
Passover.
Yes. So what do you say? Only one thing. Award was declared. Now he has to challenge. Now he has approached this writ court. I have given him liberty to take steps to challenge the award.
Yes.
Now he wants that the time during which the writ petition was pending, that is to be excluded.
Not only that, almost 2 months thereafter, passing the award, the order was communicated. Can you see the original?
When it was communicated.
Award was passed on 12th June.
Yes.
When it was communicated, Mr. Pari.
They posted in 28th July. I received in first week of August. But almost
Then
2 months.
yes, time will be computed from the date of receipt.
Mr. Pari, the law is under section 33. Time is to be computed from the date of communication,
Yes,
not from the date of award.
First week of August.
So from you have received in your first week of August, when you have filed this writ petition.
I filed a petition on my lord.
13th of August.
13th of August.
So it's within time.
Yes.
So you will be at liberty to pray for this. Time has to be excluded.
By the arbitration court under section 34.
By that court.
Yes.
He wants an observation to be made. So I'm only clarifying that. Okay.
Yes.
The That's condonable period. So, but that cannot be extended because even if it falls on a holiday, that cannot be on the next day. That's the difficulty of the second 30th day.
Not thereafter.
No, not thereafter is first is that's the condonable period.
90 days.
So there the General Clauses Act that will not apply. So it's condonable period. That 30 days, even if it falls on a day or on a Sunday or any other things,
Next day it cannot be.
that's the Supreme Court judgment on that.
No, that is very rigorous interpretation because if it is a vacation, suppose there is a vacation of
General Clauses Act and other things were considered, Mr. Banerjee. Was considered. I had the occasion.
Just in the opening day of the vacation, then it is gone. Or in the middle of a vacation. If it
That 30 days is gone.
cannot take
First 90 days, you can take the advantage. Next 30 days, no. Interpretation I had come across and I've considered that and passed an order also on that.
condonable part.
Condonable part of the second 30 days, it's difficult. No extension.
Here we 60 days. That is the correct date.
No, we'll be getting the 30 days also.
We will get.
We'll get 90 plus 30, 120. But not 121 days. Even if it is. That's the interpretation.
It's beyond 3 months.
Disposed of হয়ে গেছিল ওই
Much of it.
Yes. সাপ্লিমেন্টারি এক্সটেনশন
ও সাপ্লিমেন্টারি
সে তিনটের সময় আছে, তিনটে বাজেনি তো
তিনটে নট ইয়েট 3 হয়নি এখন জোসেফ কি বলছেন
তিনটে বাজেনি 56
No.
All that they say that in the year 2009 there is an existence of a road which I vehemently deny. Now difficulty is this, my lord. My lord, there is no acquisition proceeding. Nothing has been done. My lord, that is on record and kindly take page 5 of the report submitted by them.
No, affidavit in opposition. Oh, affidavit in opposition to the report. You have taken. All right.
But I do not know what is the opposition.
It's a bare denial.
Bare denial. But the decision was taken long time back in 2009.
Page 5.
And earthwork already completed.
Kindly takes the report.
Can you take away a property of an individual?
And now, Milord,
in the garb of saying that I will construct road, compensate.
Milord, Lordship, kindly
please acquire, please pay. We're willing to pay
Lordship, kindly see
compensation.
the letter of the Panchayat Pradhan, R1. It will speak everything, Milord. R1, Milord, the letter issued by the Panchayat to the BDO. Page 5.
Page 5.
Lordship, this is not that.
Resolution has been taken
From club, influential persons.
Kindly go through it. Kindly.
Influential persons from club, a road is to be constructed.
No.
Very influential
the
persons.
decision was taken in
আমরা
2009.
কজন ক্লাব হইতে আমরা কজন ক্লাব হইতে সুদর্শন ভৌমিকের বাড়ি পর্যন্ত ঢালাই রাস্তা হুই সুদর্শন ভৌমিক
I don't know.
Malord,
Milord, already.
I just interject, Malord. I am the only family of scheduled caste residing in that locality. Our difficulty is this is a rural area. All the other people are of general class, Malord. That I have taken specific allegation in my petition. Malord, they are all against me. All they want is to oust us from the position. But that is the specific pleading that has been taken by me in my dispute.
Did you take his consent?
No, 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 possibly not.
Please remove.
Yeah.
Please remove the road.
Kindly,
Or acquire. Yes, you are the private respondent.
Paragraph number 3.
Yes, yes.
Paragraph
Have
number.
any landed property?
My lord, the physical.
I'm asking you, do you have any landed property there?
You
don't have.
Do that, my lord, this.
Let a road be constructed there.
Diocese land, but my lord is physically, my lord, used by the villager for long back.
Physically used by
The villagers.
Let them use. Why have you made it concrete?
At the demand of my lord, and my lord, the petitioner, my lord, was a my lord erstwhile member of the Gram Panchayat.
Maybe.
And under whose supervision the road was my lord constructed and finished. That is the main.
But road is there. Road is there.
It is under your supervision this has been done.
And now my lord,
Says that.
when my lord changed
You are
the
the
board,
erstwhile Pradhan.
and when the change.
Now you have lost, now you are coming.
Millard,
Under your super, that's your
the main
statement.
Millard, only one paragraph, Millard, Lordship kindly see. Paragraph number 3 in the point later issued by the Panchayat Pradhan. Page 5, at page 5 of the report. উক্ত রাস্তাটি 2015-16 অর্থবর্ষে গ্রাম
Starting 2015-26. Why are you coming
now
up at
what
so
they are
late?
objecting.
My lord, section 25(1) of the Panchayat Act, my lord, categorically, my lord, gives an embargo that if it is a private land, my lord, the Panchayat has.
Mr. Banerjee, why are you approached so late?
My lord, now
After
they are-
10 years, on that ground itself,
Now what they are doing, my lord.
Earthwork already done.
And you take paragraph 1. Now, this
paragraph 1 of
paragraph 1 of page 5
the report.
of there.
Yes.
And you take paragraph 1. আমাদের পাড়া আমাদের সমাধান প্রকল্পের উক্ত রাস্তাটি গ্রাম পোক্তা আমরা কজন ক্লাব হইতে সুদর্শন ভৌমিকের বাড়ি পর্যন্ত সারাই রাস্তা থাকার নির্মাণের জন্য সর্বসম্মতিক্রমে সবাই পাস হয়। উক্ত রাস্তাটি ঘনশ্যাম গ্রাম পঞ্চায়েতের 237 নম্বর বুথে আমাদের পাড়া আমাদের সমাধান প্রকল্পের 4/9/2025 তারিখে রেজলিউশনের মাধ্যমে অন্তর্ভুক্ত করা হয়েছিল আন্ডার আইডি নাম্বার সাজান স্যার। উক্ত কাজটি বর্তমানে শুরু করা হয়নি, কিন্তু ওয়ার্ক অর্ডার দেওয়া হয়েছে যার মেমো নাম্বার সাজান।
The work has not been done.
Only concrete work is left. Concrete work. Road is there. Earthwork already done. Earthwork already done.
Kindly see the physical.
It is also the nature of the road. Lordship kindly. How it can be the land of the petitioner?
It cannot be land of the
No,
petitioner.
no, land on the but he has
Record of rights, what is it showing? His name.
but he has conceded. But he has not objected so long, Lord.
Under his supervision, these are baseless allegations. My client is present and he's denying this.
It's a resolution of resolution. Show me that he has constructed. He has given consent. Please show me the document.
And no contemporaneous document of 2009 and 2015 has been submitted by them.
It's a resolution of 4th of September 2025.
Yes.
Show me your resolution. Produce the copy of the resolution.
Your lordship.
আমরা কি অ্যানেক্স করেছি এই যে পরে যেগুলো আছে
Very nice to say that I'm developing, taking the property of others.
Oh, my lord, the Pradhan has no, my lord, intention to encroach or develop only for the demand, and he
Very
was
good.
also the.
So remove that. Remove that. Restore it to its original condition. I appreciate your submission that you do not have any intention to take over property. So, all right. So, how soon you will restore it to its original condition?
Only, my lord, one thing, my lord, may I subject to your lordship, my lord, correction, my lord. My lord, in case of encroachment by the, my lord, the Pradhan, that is within, my lord, the jurisdiction of the root court. But, my lord, is in case of any possession or use by the villagers, private individual, my lord, that is the subject matter of the civil court, my lord. That is the only, my lord, your lordship, my lord.
You remove the road. I will not go any further.
My lord, road is
this
existing,
construction work.
Road is existing.
Road is
No
existing.
construction has been made.
Remove
No
this
construction.
material. What have you put there?
We have
That
just
broken tiles. Broken tiles.
acquired the materials for constructing the road, but not
What have you
been
put
executed.
there? What have you put there? Broken tiles.
No.
That's I have seen that you have said that in the report.
Millard, Lordship kindly see paragraph number 2 in the report.
Yes.
In paragraph number 2 of the letter issued by the Panchayat, page 5.
Yes.
রাস্তাটি দৈর্ঘ্য 200 ফুট।
টালি সহকারে পাইলিং করা হয়।
হ্যাঁ, yes.
Do you know how that is being done? Can you walk on that road?
No, my lord.
Do you have any, sir, do you have any practical idea
My lord,
about how this piling work is done? I'm asking you as a council.
Of his,
You are not answering. I'm asking you, do you have any practical experience how this tile piling work is being done?
no, that is the concrete waste. That is, yes.
Not the concrete, tile piling. Do you have any practical experience how this is done? Perhaps not. You don't have.
That has not has been executed.
If it is kept at that, can it be utilized? I'm asking you. If it is kept at that position, can it be utilized?
No. On this just demand of the villagers, my lord.
And the villagers are,
And they are
Those who are demanding, ask them to give their land, construct there.
but the
Who is
village,
demanding, ask them to donate their land, please construct there. They must be having some land. They are the persons of that village. They want development of that village. Ask them to donate their land, you construct.
My lord, I am bowed
Very
down
easy
by
to
your
say.
bow down before your lordship's order. But my lord, only the existing road is using for
Milord, see,
that
Let
is-
it be used as it was used. Don't do any concrete, nothing. I'm
Milord,
not stopping anything, but this work cannot.
তাহলে তো ঠিকই আছে
Complying
আর কিছু বলার দরকার নেই
Yeah.
Milord, serial number 5 in the letter, Milord,
Yes.
উপস্থিত গ্রামবাসীদের কাছ থেকে জানা গেল যে রাস্তাটি মদন মোহন ভৌমিকের পিটিশনারের রায়ত জায়গার উপর এবং দীর্ঘদিন যাবৎ উক্ত রাস্তাটি এলাকার জনগণ ব্যবহার করছে
They are admitting that it's a Rayati land.
And
Yes,
my lord,
but they are using,
not
the
object-
villagers are using them.
Let them
The
use.
Lordship, can you do not stop them to
Sir,
use it?
you don't know what is the effect of doing this concrete. You do not know that. That is why.
Only 1 point.
The
my
next day you will be saying, we have done, it's vested to the government. That will be the plea taking, I'm telling you.
Let it remain as it is.
lord, when my lord, he
Hmm?
was a my lord member of the Gram Panchayat, he has no any objection.
Hmm.
And my lord, only for the my lord.
This is was he the Panchayat Pradhan on 4th of September 2025? This is the resolution on 4th of September 2025. Show me that he was a part of that Panchayat on 4th of September 2025. So this is your resolution of 4th of September 2025 to make a concrete road.
Yes,
Show
sir,
me
yes,
that he
sir,
was a
nahi.
part of that Panchayat. This is the report.
আমার কিছু দরকার নেই। হ্যাঁ, আমার কিছু দরকার নেই।
So if your lordship, my lord, be inspection, so whether
Your
any
lordship would kindly take the
resolution
pain of
has
looking
been
at page 23.
resolution
My
has
lord,
been
this is the
taken
penalty,
seriously or not, my
It is the road. How it is being utilized.
No, difficulty is this, I tell your lordship, it's
What do you want? You want compensation?
No, this was a 1 acre, 5 decimals of plot of land. Now, my lord, it's a huge plot of land, I'm one of the co-shares. Now, what they are trying to do, my lord, they are trying to make concrete on my structure. There is a courtyard, they want to go through that. They want to decimate the building there. That is the actual difficulty, that's my problem, right?
সেটা কি করে?
That is the actual difficulty.
সেটা
And,
how
my
it
lord,
is?
repeatedly, my lord, I have taken prayers before the state authorities, we conduct a survey, land survey be done. Thereafter, my lord, in accordance to law, let everything take place. But
Any alternative places there for
let them
construction?
conduct a survey, my lord. and-
I'm asking you, have you taken instructions? Any alternative space, if it can be removed to that?
Oh, there is another adjacent plot, my lord, so the boundary line, my lord.
Can be done.
Can be done.
Please see, I'm not passing any order today. I'm curious, please see if it can be resolved. Mr. Banerjee, please see if it is resolved. After all, it's for the welfare of the villagers.
Yes, yes.
I'm not passing any orders, I'm only adjourning this. But I'm restraining them from doing any further construction work.
No, I may just I have submitted a representation that is annexed in my distribution that I have asked for a survey. My lord, let the DLRO conduct a survey.
Yes,
It
that-
is lying in
My
the-
lord,
Yes, yes, that can be done.
no any.
But provided you are agreeable to give that. Survey means your plot.
Yes, survey, my lord, all the surrounding plots can also be done, and in the adjacent, in the boundary line of.
But the difficulty will be that if the adjacent plots, who is the owner, if he is not agreeable,
Yes.
then another
Let
problem will be
Let
there.
them be injuncted, my lord, then, my lord, because
Now they will be injuncted. So if it can be solved, I'm keeping it in the next week. If it can be solved, please see if the
Next week.
Your lordship,
you can only solve this problem.
Well, I will,
ground realities are different. My lord knows ground realities are different. My lord, let him video with the neutral person. Let him take to initiate.
সেটা করে দিন, সেটা করে দিন।
I have no any problem. Video.
That can be done, but that cannot be by the court's order. It's that's difficult. I'm keeping it in the next week.
Next week, my lord, I have family. There is a marriage ceremony, my lord.
Then next week,
Up to 9th.
from Monday to 9th.
No, from
Second,
yes, second. No problem.
I'm keeping it on second. The
But the lordship may mention the to negotiate this matter for to Pradhan
To negotiate.
no, my lord, for the alternative any option.
এখন কিছু করো না, পরে হবে।
Yes,
পরে
on
next
the
on
next matter.
এটা তো আমরা দিলাম না?
না, না,
Extension को टेके दिन. Regarding other matter. You see, two extensions are there. It is expiring today. হয়ে গেল সকালবেলা তাড়াহুড়ো করে মেনশন করে দেখি দেখি ফাইলটা দিন yes you are appearing
Item 2 next
who is in one one নেই তাহলে পাসওয়ার্ড করুন রাখুন টুটা ডাকুন তাহলে পাসওয়ার্ড করে রাখুন
state
yes din file ta din what is this matter Mr. Bose
But the matter relates to a land will because ultimately I was allowed to retain the particular plot of land. 14N proceeding will have completed its logical end. Thereafter, the authority who was not vested with the power Miller sought to review and Miller sought to distribute the land Miller to a particular company. Now Miller, this is I question Miller the jurisdiction of the authority.
what order you are challenging here
I am challenging Miller that you kindly seize the order first.
which order
The order passed in this writ petition.
no what order you are challenging what is the subject matter of this writ petition
Miller, the PPP project, my land, which was allowed to be retained, Miller, this land was sought to be handed over to a private concern, Miller, the government. Miller, that is Miller, the order Miller kindly seize. And the moment I gave a representation, this Miller proceeded with a review petition. Review, show motor review. I said show motor review is not with them. Kindly seize the order Miller, it narrates everything. May 22, 2025. First turn Miller, page number 18 of the petition, the order dated 16 June 2020. By this proceeding, Miller, a particular area of land was Miller allowed to be retained by my client and the remaining portion Miller stood vested in the state.
all right yes then what has been done now
Now Miller kindly sees, then Miller, the authority had completed, then Miller kindly come to page 17, the order number 896/2020.
yes 17 of the writ petition
Application, the writ petition, sorry. Order number 8, the case is taken up today, Borun Kumar Ghatok, that is my client, files Hajira, which is the part of proceeding. During this time, report from the revenue officer is tabled, which shows no government irrigation facilities over here. A different proceeding
Mr.
has
Bose,
been
an order notice under 14T3A.
Yes.
How can it be quashed in a writ petition?
Because Miller subsequently this was Miller, I moved this writ petition. These are absolutely jurisdictional. Miller. The authority
Tribunal is there, Mr. Bose.
Tribunal is there. They know.
What they know?
Kindly sees. What is the order there now? Kindly see your prayer. I said read in the nature of set aside 5th May 2025 being annexed P6 to the writ petition issued.
Yes.
Empowered authority. Then see the nature of the mandamus directing the block line officer. Sorry, read in the nature of mandamus directing, squashing and setting aside the memo dated 11th April 2025 annexed P4 to the writ petition issued by the Special Secretary Micro Small. And
no, but how prayer A can be granted in a writ petition?
Because Miller, the alternative remedy is not an absolute bar. Miller, kindly see.
Sir, both.
Miller, MSME, the contract is there. There is a Miller market complex.
The statutory
Miller, I have a judgment, Miller, to show.
Tribunal is there.
I have a judgment.
What judgment? It says it should not be gone to tribunal.
No, I have never said. It is a contested hearing. The authority state did not prefer any appeal.
No, my lord.
Kindly hear out.
No, my lord.
Kindly see.
They did not prefer any appeal from one. You are challenging a notice under 14T3A.
I am challenging two notices. First of the review power, if it is a question of jurisdiction, the review proceedings by suo motu review is not with.
Mr.
Only one thing.
Mr. Bose, when the Tribunal Act
No, kindly
By
see.
virtue of that, as tribunal has been constituted, more so the single bench power under Article 226 has been taken away.
Milord, this has Supreme Court is conscious about that. That
In
is why.
Chandra Kumar, Mr. Bose has
Is-
specifically
No,
said,
absolutely. Kindly the prayer B cannot be a jurisdiction of the tribunal. Prayer B, Milord, kindly see page 11.
you waive your prayer A, I will consider your prayer B. You waive your prayer A,
No, first of all,
Mr. Bose, no.
no, Milord,
Prayer A cannot be granted by the writ
no,
court.
Milord, kindly see only one
Do
minute.
not press your prayer A, I will consider your prayer B. Because prayer A is the main prayer.
Prayer,
A is the main prayer.
no, prayer B is also there. Milord. Kindly see.
No, prayer B I have seen.
Just a minute.
Prayer A is the main prayer.
Kindly see. Just a minute.
The prayer A,
Kindly see paragraph
that
11.
memo stands, Mr. Bose.
Paragraph 12, minute, only one. On the one hand, the petitioner has been running from pillar to post. Paragraph 12, page 6.
Paragraph 12 of the writ
petition. To get the name recorded in ROR. On the other hand, the special secretary, page 12, page 6, paragraph 12. On the one hand, though the petitioner has been running from pillar to post.
What was the subject matter of title suit numbers 174 of 2024?
Title suit Milord 174 before the civil judge given by the Arishant Landly Farm.
Yes, what was the subject matter of that suit? What was the challenge? Please show me the plaint.
The plaint is not with me at present. I can.
You have withdrawn that suit.
Yes.
What was the relief claimed in that?
Without.
Maybe the record of rights. Then running from pillar to post to get the name recorded in the record of rights.
Secretary, hereinafter if issued a correspondence to this is my such and such for setting up a market complex for
Suppose that is your retained land.
Yes.
Yes. So, but it was not recorded in your record of rights.
Yes, that is my case.
Yes.
On the one hand,
So, Mr. Bose, if a property, you are the owner of a property by way of retention under the provisions of the Estate Acquisition Act, that's your case. Now, if there is an inaction on the part of an authorities in not recording your name in the record
my
of
case
rights.
did not stop there. I mean, kindly have the charity to consider.
Yes.
Had it been a case that there is an only mere inaction, your lordship is absolutely right. I should have gone to the tribunal. Here, Milord, they went further. What they have done, Milord, the 14N proceeding, section 6(3) proceeding completed. I have shown your lordship paragraph page 17, order number 8, that 14N was completed. The High Court says when the 14N was completed, any further action, Milord, what is the moot question? There are two questions. One is land is sought to be given to a public project authority, a particular micro small scale industry. Number one. Number two, why? The moment I made a representation, they sought for a review. This BLLRO who had passed an order in 16/6/2020, which I have shown when they reflected in the order, the same BLLRO sought to review his own decision the moment I made this application. Now the question is, if it is a question of basic jurisdiction, authority to decide, authority to review, the Supreme Court has categorically stated, Milord, the High Court has the power. Supreme Court, Milord, presume that, Milord, it cannot. Kindly see 2023 2023 SCC online, Supreme Court 95. I am giving Justice Godrej Sera Limited, C Limited, versus excise and taxation. Paragraph 8, I will hand over to your lordship. That apart, we may also usefully refer to the decision of the court reported in 77 2 SCC 724 and 2000 volume 10 SCC 482. What appears on a plain reading of the former decision is that where there are certain item falls within an entry in a sales tax statute raises a pure question of law, and if investigation into fact is necessary, the High Court could entertain a writ petition in discretion, even though the alternative remedy was not availed of. And unless exercise of discretion is shown to be unreasonable or perverse, this court would not interfere. In the latter decision, this court found the issue raised by the appellant to be pristinely legal, requiring termination by the High Court without putting the appellant through the mill of statutory appeals in the hierarchy. What follows from the decision that where the controversy is purely legal one, it does not. Milord, his lordship, their lordships, they refer to decision, and then Milord.
Suppose, please show me PHR Invent 2024 decision.
2024
SCC online. PHR Invent. Please show me.
Keep it, Milord. One day I will show you, lordship.
Look into Mr. Bose. I'm not for
No.
a moment, Mr. Bose, I'm not for a moment disputing the proposition that
No, then your lordship is
alternative
asking-
efficacious, even if there is a provision in the statute,
Yes.
fan লাগবে?
কঠিন মামলা তো ঘাম হচ্ছে।
ফ্যানটা চালান।
কঠিন মামলা তো সহজ প্রশ্ন করলেই ঘাম হয়।
Even if there is a provision, alternative remedy provided, 226, 227 is not an absolute bar, Mr. Bose. I am aware of those propositions. Those
Certainly.
But in a case, because if you take the history, L. Chandra Kumar's case, there what happened, by way of an administrative tribunal's act, the power of the High Court under Article 226 was taken away. Now the question arose because there is a direct appeal to the Supreme Court from the tribunal. Now, then it was challenged whether the power under Article 226 of the High Court could have been taken away by way of a statute. Then comes L. Chandra Kumar, he says no. After that, 226, but by a division bench. Administrative Tribunals Act, Mr. Bose, will be not finding any provision akin to section 6, 7, and 8 of the West Bengal Land Reforms and Tenancy Tribunal Act, where it says it is to be exercised only by a division bench. Single bench power under 226 has been taken away by virtue of that statute. So even if I accept your submission that a writ petition is maintainable, that cannot be before a single bench.
Yes, absolutely. Milord,
That cannot be before, this is a second limb. Even if I accept, that cannot be before a single bench.
No. As your
Because Tribunal Act, because Mr. Bose, then it will be frustrating the object of the act.
I bow down to your lordship.
Because
kindly,
in most of the cases, in many
the
cases,
judgment which your lordship is referring, Milord, kindly, if your lordship will 2024 SCC online.
Page, Mr.
No,
Bose.
no.
PHR invent is you are having the gadget. That's on Surface Act. It took note of the well-known exceptions on which 226, 227 High Court can be approached.
Yes.
After noting, I think in paragraph 32 or 33 of that judgment, the next paragraph says no, when there is a properly constituted tribunal, High Court should not interfere under Article 226. Please check up that. Previous paragraph, it quotes those exceptions, well-known exceptions, what you are saying. Those line of decisions,
only
where it takes note, these are the exceptions. Those 3-4 exceptions will be there.
If I say,
when
yes. Now,
PHR invent.
But if your lordship takes it up on Monday, 3:30, I will address your lordship. Will not give me half an hour. I will show the distinguishable features, Milord, that and Justice Mukherjee, in a service matter, when the service tribunal was not in operation, his lordship has. But here,
that's the different thing.
Correct.
If you say no, the tribunal is not in CC.
That is why I'm saying.
That's the different thing.
Absolutely.
Tribunal is not here.
No. Here is tribunal is full operation.
Then
even then,
if Mr. Bose, even the tribunal, if the tribunal is not there, yes, under Article 226, 227.
Correct. Correct. Question
There
is
no power in that.
Question
but
is, Milord,
if the tribunal is functioning, taking away the power of the tribunal, exercising 226, you have got that decision.
Yes. No, not opening, Milord. PHR
invent.
PHR invent, Milord. I will try to find it. And Milord, I will show your lordship. Milord, first of all, the law does not talk about any uncertainty. Your lordship says that this particular judgment says the High Court should not. Now, Milord, on the last day of
After all, it's the discretion.
After
all, it's the discretion of the High Court
now,
whether
Milord,
to exercise.
now, Milord, if your lordship now.
You have got. You have got the decision.
He says, Milord, just a minute.
What is the cost title?
PHR invent.
Yes.
Education Society versus UCO Bank.
Yes.
Yes.
Please come to, I think, paragraph 32 onwards.
Kindly, Milord, allow me to, Milord, go through this judgment. I will address your lordship on.
Please.
32.
32, 33.
Yes. In our view, the High Court ought not to have taken into consideration that the confirmed auction sale could have been interfered with only when there was a fraud or collusion.
No, prior to one or two paragraphs prior to, it quotes the Supreme Court decisions, which says that well-known
Quote, in
exceptions.
case of Balaji Kimji Company, such and such, and others observed in the first case mentioned above, where auction is not subject to the confirmation by any
Please
authority.
give it to me.
Nine.
29.
29.
Please take paragraph 37. This takes notes of those four well-known exceptions where Article 226 and 227 can be exercised.
But the statutory authority has not acted in accordance with the provision of the
No,
enactment.
37 carved out certain exceptions when a petition under Article 226 of the
Yes,
Constitution
It-
can be entertained in spite of availability of alternative remedies.
Yeah, but the statutory
Some of
authority has
them,
not acted.
four exceptions have been taken note of. Then paragraph 38. It has, however, been clarified that the High Court will not entertain a petition under Article 227 of the if an effective alternative remedy is available to the aggrieved person or the statute under which the action complained of has taken itself contains a mechanism for redressal of the grievances. This statute contains a redressal of the grievances. Supreme Court has times and again said, no, don't interfere. And I tell you, Mr. Bose, in some judgments of the High Courts, it was entertained. Caustic remarks have been made by the Supreme Court on that. There is also 3 judges bench prior to this PHR.
Millard, if I
saying,
just like
mentioning the courts, thankfully, our court is not one of them.
Millard, I cannot.
Appropriate remedies
Millard,
there,
I
Mr.
cannot.
Bose.
Millard, yes. Millard, prayer B cannot be redressed by the tribunal. If your lordship sends me there.
Prayer A is the main prayer, Mr. Bose.
Yes, but prayer B, Millard, is preceded. Prayer B precedes prayer A because prayer B first, then prayer A started.
Mr. Bose, your primary relief, you have been allowed to retain some land under the provisions of the West Bengal Estate Acquisition Act.
Right.
Now the difficulty is that those lands have not been mutated in your name in the record of rights.
Mutation does not, Millard, convey any title today, subject to correction.
I have said that the problem is it has not been mutated in your name.
Right.
I'm not saying that the mutation confers title, your property has gone because it has not been mutated.
No.
But since it was not mutated, maybe perhaps the second consequential step which you are saying that it was allotted to some other person.
Attempted to be allotted.
Attempted to be given to some other person. So basically now in the meantime, what they are trying to do, this retention order is sought to be reviewed.
Where is that power?
That is why. So there is, I'm not saying there is a power. So that's an action which has to be, is an action or inaction in whatever name you call.
No, if I say.
And of a specified, of an authority under that specified
Millard,
act.
yes, Millard, only one indulgence, Millard. Whether I can impress upon your lordship, Millard, it's a judicial mind, I can reopen it at any time. Millard, 6 and 8 specified act says that certain order passed under the specified act, and section 8 says go to the tribunal 1997 act. Thereafter amendment took place, it said initially there was no provision that if there is an inaction, I can go to the tribunal. The legislature became conscious, they incorporated the provision.
Inaction also.
Yes, even if I cannot come against an inaction before your lordship, High Court, that is also settled. But question is the power to review of its own order it must flow from the statute because source of power is an essential question of law. Number one, it is a substantial question of law. If your lordship says that this is a power exercised by the authority under a statute as a sequel thereto as a result whereof this order was passed, I could have understood that your lordship says that go to the tribunal and this is there. I said if the power to review its own order is not within this realm of the statute, and if such power has been exercised by the authority, that cannot be an order under the statute. Kindly have a vision to that. If your lordship says the power to review is well within the statute.
That is why, Mr. Bose, it falls within four
Milord,
well-known
Milord,
exceptions.
yes. Now, Milord,
Given that,
1997 L. Chandra Kumar.
Mr. Bose, taking note of that,
Yes.
it has been said, even we are taking note of those.
Milord,
That comes within
no.
one of these four exceptions.
Right, comes with the four. Here, Milord, the authority essentially says, Milord, one is error within the jurisdiction and jurisdictional error. I said, Milord, this order passed under a statute. The order must be power under a statute means the within the statutory power. If the statute
You cannot take that point before the tribunal.
no, I'm not saying so.
Then-
I'm not saying so.
then-
But question is, Milord, like Milord, the return of plane, I am taking the plane today and go there, Milord, on the same day. Milord, today, if your lordship gives the permission, that Milord on Monday, at the first sitting, Milord, I will prepare, Milord, the interim order, Milord, may kindly be continued for 7 days or 5 days. Within 48 hours, I can file and I can renew my prayer before the tribunal. That can be done. That can be done. But at the same time, but prayer be, Milord, that part, Milord, the MSCP will be taken because MSCP, because this power, Milord, tribunal say I cannot take. So where I will go, Milord, I put this question.
Where is the MSME? Where is that document?
P4.
Yes, what do you say?
That we have filed out, my lord, affidavit, my lord, on the last occasion, my lord. And my lord, we have specifically taken, my lord, on the last occasion, this representation is not maintainable. There is a specific bar that has not been considered, my lord, on the last occasion. But we have taken, my lord.
What you say to prayer B? Can it be maintained before the tribunal?
My lord,
Prayer B.
my lord, we have passed an order.
Does the tribunal have the power to grant prayer B?
Prayer B is related with our prayer A, my lord.
কি আশ্চর্য কথা প্রেয়ার বি প্রথমে এলো তারপরে তো প্রেয়ার এলো সঙ্গে সঙ্গে রিভিউ করতে হবে 44 পাতাটা দেখো
But whatever order has been passed by the my lord authority, that is my lord.
প্রিন্সিপাল সেক্রেটারি এমএসসিবি
Who is leading you?
Mr. Soumitra Bandyopadhyay. Kindly fix the date for next week, my lord.
Where is he?
But is in another.
সবে ইলেকশন গেল
Suppose you are only delaying. You can go before the tribunal.
kindly সৌমিত্র বন্দ্যোপাধ্যায় learned senior counsel will address your lordship. We will learn something. No, he is my senior.
Not that, but for this matter,
For this matter, every matter is a very important to your lordship.
I'm not saying it's not an important matter.
But kindly
The
see
question
two
of-
different cause of action to different court and one is intricately related to each other.
Because-
Tribunal say I will not address.
There are two things. One is whether 226 is maintainable.
Right.
Second is, even if it is, I accept your argument, whether it's before the single bench or the division bench,
Single bench.
subject to correction.
Milord, I will show a
If the
decision against
statute
me.
says, Mr. Bose, there will be a difficulty. Now, let us accept your submission and say, yes, I interfere you on this.
Yes.
Now-
Your lordship appear, accept my submission.
Yes, and I interfere with that order, say no. And I direct the authorities to take steps. Now, thereafter, and some order is passed. Now, which is challenged thereafter before the tribunal, close from that same order. After that, where will be challenged? Self-same proceedings, once culminated, you will at one stage will come before the single bench. The second
All
stage
right,
will
Milord, I
come
have to
before
answer
the
this question.
division bench.
Kindly take সৌমিত্রদা কবে সময় হবে বলো
Next
বলবা?
week, next week.
বুধবার করবে
Please consider this.
Yes, Milord.
Because-
Right. I have no answer today, just this point. I cannot play with the court, but first point I will try to satisfy, but this point I need to look into. Milord, kindly extend for a limited period.
Also consider L. Chandra Kumar.
Yes, I will
because
bring all. I will bring one judgment of justice.
Those have
Abdul Gani.
considered this provision in administrative tribunal. I have said,
Yes.
even if not before
Milord,
the
I tell
single
you-
bench, before the division
Milord,
bench.
I tell your lordship one thing, in a DA matter, before justice stand and division bench, Milord, I applied for an addition of party. I did not file any application before the West Bengal State Administrative Tribunal. Honorable Division Bench presided by Justice Tandon said that Supreme Court in 2010 presided over by Justice Ganguly Miller categorically state that is the first court you must approach there, which your lordship says you go there. Miller, the then Advocate General Mr. Mukherjee Miller, by reason of his usual magnanimity, said, I am waiving this point. The court accepted. Ultimately, the division bench of justice presided by Justice Tandon Miller passed an order in our favor in a review application. We sought for impleachment, Miller, in that petition. Miller, the judgment, Miller, I will open all pages, Miller, the judgment which will stand against me, which will lend assistance to my learned friend's client. I will also show this judgment. I do not want to play a fraud upon the court. I show all pages, all cards, and I will show that, Miller, that the court must not create a climate of uncertainty. On the one hand, court pushes me to the tribunal, asking me to redress your grievance to that point, and B, it will be left unaddressed, and I have to come to High Court, which are intricately intertwined or inextricably connected with each other. Then where I will go, I put this question. High Court, if it says, because the MSME decision was taken first, the moment they take a decision first, and I filed an application, they became wiser. They immediately started without 14 and review proceeding. And review power is not with them. If the power is with them, how can we say that this is a power exercise under the Act? If this is not a power exercise under the Act, why I cannot pursue your lordship, that your lordship kindly ignore Miller the L. Chandra Kumar? In such a situation, ask him to produce one single judgment where this case has been happened, that a power which is unknown to the statute, legislature never thought fit and proper that a logical journey was completed by under section 14A and High Court Justice Samsuddin Ahmed's judgment, that the moment 14A is complete, the matter ends there. There is no scope for further inquiry. And your lordship has many a time said that the authority is not permitted for a roving inquiry. It's a roving inquiry. And in order to satisfy Millard, a particular industry, Millard, the government has taken the decision. As a
A wonderful case before the tribunal, Mr.
Millard, I will come.
Will succeed before
No,
the
Millard,
tribunal.
I need your lordship's blessings all the time, Millard. But at the same time, let Mr. Bandyopadhyay come, Millard, and it will be a music to your lordship's ears. Kindly, Millard, allow me to come. মঙ্গলবার করবেন হ্যাঁ মঙ্গলবার 3:30 না না
Entry order is still which date?
আজকে লাস্ট ডেট নভেম্বর
Last date of November, so
Monday both. Only 2 days in Tuesday I will not ask for it. I will complete my argument, Millard. I would love to, Millard, embrace the death at the hands of your lordship. It's a legal death, Millard. time fixed 3 PM.
Fixing may be a problem. Let it
Okay.
appear, then if you are in difficulty, your junior will start, you may join them. Huh? The same heading টা
হ্যাঁ
Yes.
রিপোর্ট দিয়েছে
We have filed a report in the form of
রিপোর্ট
evidence.
এক্সেপশন ওই এভিডেভিডই
then let it be hard. কবে?
হ্যাঁ
জানুয়ারি মাসে